2015. My name is John Michael. I work with the Metro Codes Department, and I'll be presenting the cases to the board for their review in each of today's public hearings. Respectfully, to members of the audience, we would ask if you would please silence your phones, tablets, other items, just so that it won't do anything to interrupt the board's proceedings for each of the cases. And obviously, we thank you for that accommodation. For today's public hearings, the board reviews correspondence that's been submitted in support of and opposition to the cases that are being presented today. The board also reviews correspondence and recommendations from other government agencies. In today's hearings, the staff will present the site plans, photographs, maps, and other documents that comprise the case record. At the conclusion of the staff presentation, each appellant will then have the opportunity to come forward and make his or her case to the board. After the appellant's presentation, the board would hear from any of those wishing to speak in support of the appeal. After that time, if the appeal has opposition, the board would then hear from those parties. After the opposition speaks with their presentations, the appellant will have the opportunity to present a rebuttal. Under BZA rules, an appellant has 10 minutes for presentation if there's no opposition present. For contested cases, BZA rules allow 15 minutes to each side for the presentation of testimony. Should the appellant wish to provide rebuttal testimony, it's imperative that he or she reserve some portion of that originally allotted 15 minutes. At the conclusion of each hearing, the board will deliberate and then vote on the case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, namely Section 17.40.180. All section numbers that we referred to today come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1, 1998. I'll introduce the entire Zoning Code and make it part of today's record. The Metro Code requires a record of all of these proceedings because the BZA meetings are recorded and later broadcast to public access television and later uploaded to YouTube. It is imperative that anyone coming to address the board please come to the front table, turn on the microphone, introduce yourself by name and address, and then make the desired presentation. The Metro Code requires 4 members of our 7-member board in order to establish quorum, which we just do have at this time. In the event that only 4 members are present and an appeal fails to receive 4 affirmative votes, the appeal will be re-advertised for the next available public hearing. In the event that 5 or more members are present and the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to the Chancery Court within 60 days of the hearing date. Additionally, an aggrieved party may, in some circumstances, file a motion for rehearing within 60 days of the original hearing date, pursuant to the terms of the BZA rules and regulations. After that time elapses, the board's decision becomes final, and no further action can be taken. For the appellants, if your appeal is granted, you are in fact required to obtain the permit for which you are appealing today. A permit must be obtained within 2 years in order for a board approval to remain valid. After that time, you're left to start from scratch. It should also be noted that if any false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing. Our chairman is out of the country today, and as a result, our vice chairman, Mr. Taylor, will preside over today's meeting. Mr. Vice Chairman, I would submit that all the cases for today's meeting have been filed in the proper order. All appellants have been properly notified by certified mail, and all legal notice requirements have been fulfilled. As a preliminary announcement for the benefit of both the board and the audience, we have 3 cases that have been deferred from today's docket. The first is case 2017-036. Involving property at 402 South 11th Street in East Nashville. That case will be deferred to a later date. Second, case 2017-084 involving property at 804 Montrose Avenue. That case will be deferred to a later date. And finally, as of this morning, case 2017-098 involving property at 762 Roycroft Place. That case will be deferred to the second meeting in May of 2017. Mr. Vice Chairman, at the beginning of our meetings, as you know, we like to use the opportunity to recognize any elected officials that are with us, whether they be council members, state representatives, or otherwise. I know that we have Councilmember Brett Withers with us from Council District Number 6. Seeing none other, I will invite Councilman Withers. Do you wish to address the board here at the outset of the meeting? Yes, please. Very well. Councilman Withers.
Good afternoon, board members. My name is Brett Withers, and I'm the Metro Council representative for District 6 in East Nashville. And I just wanted to speak for a couple of minutes. My schedule doesn't permit me to stay this afternoon, but wanted to speak for a couple of minutes on case 2017-101, which is for an application for Nashville Classical School in a Metro-owned property located at 1310 Ordway Place. And the application is to add a modular learning center on that campus, and there has been some discussion about that for a little while in the community. A community meeting was held at Nashville Classical some weeks ago, and we had some neighbors that were in attendance. There was a Metro Historic Zoning Commission hearing on the case, at which time the Metro Historic Zoning Commissioners recommended approval at least of the structure itself, its height, massing, materials, location, and things of that nature. A subsequent community meeting was held just this past Monday, and some of the neighbors were able to attend that meeting as well. In particular, I think some of the neighbors are here today from the Gartland Avenue side of that property that back up to that. I certainly respect their concerns and want the board to weigh those carefully in terms of determining how we get people in and out of that campus. As a city, we are sometimes in positions of having schools in very, very dense areas with narrower streets than in more suburban locations. And this exemplifies that. This building's a little over 100 years old. And so, of course, when it was built, everyone walked to school. And today we have quite a few more people that drive their children to school, and we have delivery vehicles and things that weren't contemplated 100 or so years ago. So the mechanics of getting everyone in and out of those spaces is very much a challenge. Having said that, again, this building originally was a school. It was operated as Ross Elementary until not too long in the past. My understanding is that Ross Elementary actually outgrew that building, and a new structure was completed a couple of blocks away. And then the structure had some other Metro uses for a while. And during the previous council session, a 10-year lease was approved by the Metro Council for Nashville Classical School at this site. They're about 3 years into that, and they have about 7 years to go. As is often the case with particularly with charter schools, sometimes they start out with a certain number of grade levels and add as they go, and the school is in a position of really needing to accommodate the students that they are serving in an acceptable manner. They have done a very efficient use of the building that they have, but they do need more room. I was able to tour that facility with Principal Charlie Friedman, who's here today, as well as with our school board member, Christian Buggs, and we took a look at the use of the building and the site, and I think everyone's in agreement that something needs to be done to help provide an adequate learning environment for students, and that's a big priority for our city. So again, I'm here to speak in favor of the application generally. There's been a lot of discussion about placement, the school, the placement of the structure, the school and their vendor that will actually construct and deliver the unit have entertained some aesthetic things to make it possible to look a little bit better. Some of those are more feasible than others. And again, the actual structure has been recommended for approval by the Historic Zoning Commission. Certainly landscaping and things of that nature could help, and that's not something that the Historic Zoning Commission has within their purview to review. So any of those concerns that neighbors have that you wish to entertain about suggestions about where deliveries are located. I mean, any of those kinds of concerns are certainly valid, but I do just want to reiterate that with a fourth grade starting this fall, that the school is in a position of needing to go ahead and hopefully earn your approval today for whatever variation of a site plan you would see fit to approve. So with that, I'll conclude my comments, but I'm available if you have any questions for me.
Thank you, Councilman Withers, for being here. One of the things that you'd mentioned was that the the Historic Zoning Commission had approved the structure itself, but wasn't able to have a landscape plan recommendation. But the planning department staff did recommend that we approve this with conditions that included comply with the MHZC conditions, any that they set, but then also prepare a landscape plan that includes screening of the parking areas and modular structure, in addition to meeting code requirements for approval by the urban forester and historic zoning staff prior to issuing a permit. Is that the type of thing that you said would be helpful to alleviate some of the concerns and issues that people have?
I do, and in particular, I think that is the landscaping is most helpful for the frontage along Ordway and 14th, which is visible from the neighborhood. Some of the neighbors are here who are from the Gartland Avenue side of the building, and they share an alley, and their concerns are not necessarily landscape oriented, but they're still legitimate concerns just to figure out how those things would be recommended. Okay,
that was the third recommendation of the planning staff, was limit access to the alley. It doesn't say, it may in the content, but it doesn't say in the recommendation what that should be limited to. Mm-hmm. But at least it recognizes that there is an alley a concern by some of the folks for the alley.
Yes.
Okay.
So, but like I said, I believe one of the neighbors that shares that alley is here today, and so
can talk about that.
Those are all great things to talk about and see at least what we can do with that very limited space.
Okay, great. Thank you so much.
All right. Thank you so much.
I have a question as well.
Sure.
Oftentimes, Metro Public Works requires right-of-way dedication off the alley, trying to make alleys maybe 20 feet wide. Have you heard of any discussion of that?
I have not heard of a discussion of an improvement of the alley, at least at this stage. One of the things that we discussed at the community meeting and that I think we need to continue to discuss with the neighborhood as a whole is that, Nashville Classical has a lease for about 7 more years, and doing a permanent widening of the alley would be a significant expense, but would also be that would have implications for what the use of this property is going to be long term, which may be fine. And what I would encourage the Lockland Springs neighborhood and Classical to continue to discuss is the long term. It's the highest and best long-term use of this property to be utilized in that form. And if that is the case, then to use it as a school in that manner, then I think it makes sense to work with Public Works and perhaps the capital improvements budget or things like that to do a permanent upgrade. But for me, myself, I haven't received a recommendation from Public Works for them to widen the alley specifically, at least at this stage.
Councilman, have you heard any or received any complaints about traffic, especially during pickup on Ordway, I guess it is?
It's a congested street, yes, sir.
Is there any plan in the works to alleviate that? It seems like they're going to be increasing the number of students and trips there. I drive through there pretty often myself, and it's pretty much a nightmare in the afternoons.
It's definitely quite a congested street. Mr. Friedman, who's the principal, is here, and he can speak to what their pickup and drop-off plans are, and as well as I believe he has some information about the schedule changes that they're contemplating and different modes of transportation, additional bus uses that may alleviate some of those concerns. But that definitely is a concern.
Any other questions? As always, appreciate you being here. Right. Thank you.
Thank you so much.
The BZA utilizes a consent agenda with each of its meetings. One board member reviews the cases on the day's docket and determines in advance of the hearing which cases where the appellant just met the criteria for the requested action. If the reviewing board member determines that testimony in the case would not alter the material facts, then that case is recommended to the board for its approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to either of the two cases recommended for consent agenda, please indicate by raising your hand. We can just remove it from consent agenda and hear it in the normal order. I would encourage you to wait until we announce the consent agenda before opposing any of the cases on consent agenda. Let me identify those two real quick. The first is case number 2017-097, involving the property at 178 Kenner Avenue, requesting a variance from side setback requirements. Is there anyone here in opposition to case number 97? Okay, very well. We'll remove that from the consent agenda and hear it in its regular order. The second and final case for the consent agenda is item 2017-099, involving the property at 205 Kenneth Drive in Council District Number 2, a request for a variance from street setback requirements. Is there anyone here in opposition to case 2017-099? Seeing none, that will be the one case formally recommended to the board for consent agenda. With the vice chairman having so moved, we would solicit board vote on the consent
Okay,
agenda.
yeah, we have a motion.
I'll second.
All in favor?
Aye.
Any opposed? The consent agenda passes.
For the one case, case 99, the appellant's welcome to leave. You're welcome to stay also if you wish. You have permission to apply for the permit with that variance, and you could see the code staff as early as tomorrow to process your request. Mr. Vice Chairman, absent that, we'll proceed with the first case to be heard by the board.
No, she, that,
Here you go.
Thank you so much. Richard King.
First case presented to the board today is case 2017-090 involving the property at 1211 Battlefield Drive. This is an item A appeal involving a short-term rental property. The application for the short-term rental permit was denied based upon prior operation of a short-term rental at the subject property in violation of the ordinance. Zoning map shown here gives you an idea of the layout of the neighborhood vis-a-vis other residential properties nearby. Aerial view shows you where the house is located. Emily Walters is the appellant. Ms. Walters, if you're present, please come forward, take a seat before the board. Make it a point to turn on the microphone there if you would. Is there any opposition present for case number 090? Seeing none. Ms. Walters will have 10 minutes to make her desired presentation to the board on this item A appeal. Ms. Walters.
Well, I'm completely uninitiated with this process, so I hope I do okay. I came into, I found out I was not in compliance with the requirement of a permit, so I came in because of a call from Airbnb, not to discuss my particular listing, but to discuss all the legislation that was pending that I didn't know anything about. So I went online and read everything about it and became aware that I should have been, I should have had a permit for the small apartment that I have used Airbnb to lease on the back of my house. So as soon as I became aware, I went down to Codes to apply for one and told him that I had an Airbnb listing, and the gentleman that I spoke to said I would be denied because I had already operated without a permit and that I could appeal. So that is what I have done. In the meantime, I've done a tremendous amount of research about all of the legislation pending, and also trying to grapple with how I was not aware that it should have been permitted. And there's different accountings of how many Airbnbs are operating without permits. I think it suffices to say it's probably half of the Airbnbs. And I actually think that that's conservative because I've gone into the census tracts to see where the permits are, and then I've gone to Airbnb to look at the map to see all the listings. And I guess I did all that to prove to myself and to also say that there's obviously an awareness gap, and I fell prey to that. So I'd like to file for appeal and hope that I get permitted, because there's nothing more that I want to do than comply with, all of the legislation or whatever. I'm sorry, I'm really bad at this. I'm not a professional. But I have to assume that there's some subjectivity to it, because I have also done a lot of time on the Metro website and have found other listings that have permit dates that have been issued after they were already operating. So I have to assume that there's some subjectivity to it.
Yeah, a lot of those have come here for the same reason you are, is that they were told they couldn't have a permit till they came and got a permit, and they appealed, and they were granted a permit for the reasons that were appropriate to them and their cases. But the questions that we usually ask are, is this an owner-occupied home? This is your home.
This is my home.
And when did you start renting the home?
Well, I've been on Airbnb since 2013.
Okay.
And I just dabbled in it. We've always rented this apartment out. It's not something, it's not a new venture or entity.
It was a monthly rental, and then
monthly and short term. I've had any number of people say, I've had friends who are doing trial separations. Right. I've had, you name it. And so I started dabbling. I guess I got onto Airbnb in 2013. I dabbled a little bit. In 2015, I did more business. In 2016, because of my work schedule, I started managing it actively, and I do manage it actively. I'm always there. I greet people. I do the housekeeping. I do everything. It's a small apartment on the back of my house.
Okay. And then when you were told by the people at Codes that you were operating, and you weren't operating in a legal manner, you didn't have a permit, did you stop renting? Did you take the Airbnb listings down? Is it still listed now?
I turned off, I made it unavailable after dates that I already had booked, because I was already not in compliance, and I just hated to cancel on people. I also have superhost status because of the exemplary business that I've run, and I would immediately lose that if I canceled on people. So what I did is I blacked off my calendar after the last date that I had booked.
How many dates did you rent after that?
Specific dates,
About how, when was the last time someone rented the home?
I have someone there now.
Okay. And then do you have any in the future from today?
Yes, I do.
Okay.
Because I didn't want to cancel on anybody until I found out what was going on, but I did block it off. And only, I guess, to answer your question more succinctly, I only stuck to the ones that I had committed.
So have you been, were you cited? How did you get, you actually were proactive and went to court.
I came down here and I said I'm not.
Cited, you haven't been summoned to environmental
Never,
court or
by
anything like
anyone.
that? Okay.
I'm sorry.
Are there any questions? Any questions?
So your next booking is when? You're scheduled to rent it out when?
I have someone there now.
What's the one after the one that's there now?
The next day, which is tomorrow. And these, these were bookings that I had in advance. I made it unavailable, but I stopped short of canceling on every single person that I had because I didn't know what was going to happen, and I felt really bad about doing it, and I would also lose my host status if I did that.
How many have you got, how many times is it booked between now and the next 90 days?
How many times is it booked?
Mm-hmm.
I can't, I don't know. I could look on my phone and try to ascertain. I don't know if you mean individual days or individual guests.
Well, what we're trying to determine is people come before us and say, we didn't know about this. A lot of people do cancel, and I understand you wanted to maintain your good status, but other people take that hit and they cancel when they find out that they're not in compliance. So while I understand what you're doing, I'm trying to determine how many times you had, how full was it? Because we'll take that into consideration when we're talking about what we're going to do. Mm-hmm. That is, what penalty have you had? You haven't canceled anything, you just haven't booked any more, right?
Well, I negated possible bookings. I only
Right.
stuck with the ones that were already scheduled.
I understand, and I'm asking how many that is, and you can't tell me.
I mean, would you say it's 5 or 50? I mean, ballpark.
How many bookings I have missed out on because
No,
I have?
how many bookings do you have scheduled? Not individual dates, but how many people have booked that are on the books now, and you're just waiting for those days to arrive?
Probably 10 or 12.
Okay. And would you say that's in the next month or in the next 6 months?
In the next 2 months.
Okay. Thank you.
And just to help you understand, until the latest legislation was passed, anyone that came to us and said that they had rented prior to getting their permit by Metro statute was required to wait a year. We didn't have any flexibility. If you admitted that you had rented, then the penalty was a year. And the new statute allows us to provide a penalty up to a year. And as you heard, the best case scenario is someone who didn't know, tried to do the right thing, and immediately stopped when they were told they weren't doing the right thing. You weren't quite at that level, but you did make an effort to say, okay, hey, I need to stop what's out there. You're not the first person to come in with that scenario. But as we look at it, it's not the ideal case, because the ideal case is, hey, I was told I didn't have a permit, so I didn't do any more. So that's just where, I'm just so you know where we are in terms of what we're allowed to do and how we need to be thinking about it.
I appreciate that. I guess in my defense, I mean, the whole thing just threw myself and my husband into a panic.
Right.
We immediately called my city councilman to discuss the matter with him, and then he said, "Why don't you compose a letter to me?" Or he spoke to my husband. We were
Right.
both in the room. Russ Pulley. He said, "Will you compose a letter to me explaining all of this?" And I did a very long
Right.
and thorough one. Because I was concerned, what is the subjectivity of it? What are the issues? I don't know anything about it. I'm not a real estate professional. I'm not a professional Airbnb person. I want to comply. Help me comply. And he wrote back to me. He said, "I'll get back to you," and I never heard from him.
Right, and that sentiment is something that's respected by this board. I will say, we do have a respect for folks that want to do the right thing, and it just is, what is the past, what is the history of it, and what is the appropriate resolution is what we'll be talking about. Is there any other questions? Do you have anything else that you would like to tell us?
Other than my communique with Mr. Pulley, I mean, I just didn't know, and I told him. My meeting down at Codes was 5 minutes,
Right.
and I was out the door.
Right.
And I didn't really, I was just grappling with what I was supposed to do. And that night I wrote him a very lengthy email. So I guess I have obviously dropped the ball in any number of ways, but I did try to find out what I needed to do
Right.
to seek compliance. And I didn't get any assistance.
Okay.
So other than that, I run a great business. I don't have one of these Airbnbs that's contested, which I appreciate all sides
Right.
of. It's a little tiny apartment. I run it an immaculate business, and I'm a great agent for the city. And I hope that it will be approved because I went down there immediately
Right.
to comply.
Okay.
I have one more question. What is your nightly rental?
Anywhere from $70 to $100.
Thank you.
Just out of curiosity, you've been renting it now for like 4 years?
Well, I've rented it as long as I've owned the house, which is 12.
I'm talking about under the Airbnb.
3.
And how did you find out about what you have to do?
Airbnb called me just prior to me coming down here. They actually called me on the phone. And they wanted to, I guess probably because of my superhost status, they wanted to see if I could be an advocate at some of these community meetings about all of the legislation. And one reason why I was so woefully unaware of all of this legislation is I don't have any friends who are on Airbnb. I'm not really active in the community. And every now and then I would have somebody ask me, or I'd have some pedestrian awareness that there was so much debate over the non-owner occupied and the effect that it was having on citizens and the effect it was having on real estate inventory and everything else, all of which I appreciated but didn't feel was relevant to my situation because I live in my house. So I hadn't really paid much attention to it. Airbnb called me to see if I would be an advocate at some meetings or some hearings, I don't really know, that were coming up regarding pending legislation. And I said, well, yeah, and I spoke to the guy for a good long while, pleasant fellow. So I got online and I read all of the stories regarding the permits and who has to have permits. I was aware that not only did I not have a permit, but I should have been paying a hotel tax, which I'm more than happy to comply with as well. In fact, went on their website to comply with that, but I had to have a permit number before I could pay any taxes. So that is how I became aware, the call from Airbnb. We don't take the paper. My husband used to work for the Tennessean, and for that reason, we sort of boycott it and we don't read it. And that's where I found most of the stories that made me aware of what I should have been doing.
Yeah, I was just curious. and I salute Airbnb for contacting you. That's
Well, I appreciated it. I still don't know too much about all of the legislation as far as the non-owner occupied, but I don't have one of the Airbnbs that's so contested or is so concerning to citizens. So.
Any other questions? Okay, we're going to close the public hearing and we'll discuss this. Thoughts?
Already said, this is a situation that's not the perfect scenario that we look for, but we do have somebody, and I want to make it clear, I understood her to say Airbnb didn't call her and say she needed a permit. They called her for a totally different reason, and upon doing research, she educated herself enough to figure out that she needed a permit. And then she came down here to do that, which we applaud. That's exactly what we want people to do, however they find out. But as I was saying, we are in a situation where she did, it's a tough spot for us. I don't want people to cancel on their commitments. At the same time, we do have people that do that. So I think in accordance with what we have done with other people, I think we've got to do something in this scenario, some level of punitive action on our part. I'm open for discussion on what we think that should be, but that is, and I'll ask, are we a court of competent jurisdiction able to impose a $50 fine per day? Okay, so our ability is solely with the length of time wherein they can or cannot have the permit.
That's correct.
Okay.
Any other thoughts on this?
I thought there was a fine that was going to be assessed just through the metro ordinances.
There
that
is,
gone?
and that's done through the environmental court.
Okay, so she will be assessed some penalties, some
If
financial.
in fact there is an environmental court case, that is one of the options available to the court. I took the question to be, is that an option here at the Board of Zoning Appeals? No fines are part of the punishment that you can mete out.
And the applicant said that there was no citation or current violation, which is supportive on the testimony that they operate in a way that isn't bothersome to neighbors, because that's typically how those get reported. That said, if we said, hey, you can apply for a permit at some point in time in the future, and it is rented between today and that point in time in the future, then that would be a violation and would subject the applicant to any type of penalties that environmental court might give should she be cited for that. So I guess the question is to you all is what is the appropriate date from today until when we're allowed, a year from now, or less, depending upon whether you decide it's when they were cited or came down here, that this applicant should have a permit.
I was looking at the record, and it appears that I'm assuming this is when the appeal was filed, is the 3rd of March, the date that's on that first page. Is that?
That's the permit application date, and typically the appeal date is the same.
Gotcha. Okay. So technically, it's been a little over a month since the process started. I think the last time we imposed an actual penalty beyond time served, it was similar in that they had not canceled. But I don't remember if they had taken new reservations after the process had started. I think it's pretty similar to this. It feels that way, and I think we ended up 3 to 4 months, something like that.
Or somewhere.
Yeah, this doesn't quite
Somewhere
seem
2
as
to 4, I
egregious
think.
to me. So I mean, I'm trying to suss this out so we have something on the record. So when we come to this, it's not arbitrary. But I think 2 months is sort of the maximum that I would be willing to go from today.
I'm agreeable with that, but does that mean, but the effect of that means if she can't apply for a permit, if she honors those contracts between now and then, she is in violation?
That's correct.
And it's her choice whether she continues the violation or not.
And, yeah.
That's right.
I would think that if she did, that would negate our judgment because she would have to be back here.
Well, I'm just saying, are we conditioning it on, are we saying you can apply for a permit in 60 days with the understanding that you will be in compliance when you come back to apply for the permit?
Yes. And that would include renting and advertising, I believe is the statute reads.
I'm agreeable with that.
Yeah, and I am too. And you know, that one of the things that we may as a board find helpful is some information back from environmental court and what they do, because we're independent boards, but sometimes it is nice to know if we decide something, let's say we said there's a penalty, a 2-month penalty, and the applicant, and I'm not suggesting at all that this applicant will do that, but hypothetically, an applicant did decide to rent and was cited and went to environmental court, then there are even more severe penalties that they can offer, and there have been cases that I've heard about where, you know, folks that have gotten their permit ended up in environmental court, lost their permit for a couple of years. So it is a whole separate system. It frankly has a lot stricter penalty options than what we're allowed to do. So I think that this is a really good situation for most applicants if they actually do what we say. So anyway, so just FYI, because we have several STRP cases coming up.
And if there is a violation, then that's reason for show cause, and that'll take care of itself, and we'll make that a condition.
That's right.
And, you know, it might not even end up in environmental court.
So it sounds like we're headed toward a motion. Does somebody have a motion they'd like?
I move that we find that the administrator was correct in his decision, and that we make the suspension of the, I don't know, it's not really a suspension. The applicant will be eligible for a permit 2 months from this date. Does that sound okay, legal? Okay.
2 months from today or 2 months from March 3rd?
From today.
What?
Is there a second?
I'll second.
We have a motion and we have a second. Is there?
I want to clarify. The appellant will know that if she rents it until she gets a permit, she's in violation.
That's right.
Subject to.
Did we understand that to be a condition of the motion, Mr. Harper?
I will make it a condition. Can I offer an amendment to my own motion? Can I do that? I'll amend my motion, the condition being that the applicant is in full compliance at the end of the 2 months.
Is that acceptable?
It is to me.
Okay. We have a motion. We have a second. Any more discussion? All in favor of the motion, say aye. Aye. Anyone opposed to the motion?
I'll say aye, pardon me.
Okay, motion passes 5-0. That means you're eligible for a permit in 2 months, but you do have to cancel those reservations. If you choose not to cancel the reservations, it's certainly your choice, but you are in violation and you wouldn't be able to come back and get a permit, and we wouldn't view it very favorably, and the environmental court wouldn't. And I will just say, just because you're new and you're new to the process, this is, you know, the very best penalty are those that do completely, you know, stop renting. Usually by the time they get here, they have had about a 2-month penalty, and that's sufficient because you kept renting. And again, you didn't know, and I understand that, and very empathetic to that. But because you didn't, you kind of have that next level, which is the 2 months. So certainly not ideal, but it's certainly what we would deem to be a really fair decision for you. So that's where we are. So
Move to the next case, Mr. Vice Chairman. That's case number 2017-092 involving the property at 2311 Maddie Street. The appellant, Kathleen Ann Bell, is the appellant and owner of the subject property. This, too, is an Item A appeal involving a short-term rental permit, one that was issued in error by the code staff in the R10 zoning district. The zoning map here shows the R10 zoned property just up off of Buena Vista Pike. The aerial shows you the approximate layout of the residential neighborhood there. The appellant is represented by counsel. Is there anyone here in opposition to case number 92? Seeing none, we would invite the appellant and counsel forward at this time to make the desired presentation to the board. You'll have 10 minutes to make such presentation.
Good afternoon. My name is Michael Wren. I am here on behalf of Kathleen Bell. She is the owner of the property located at 2311 Maddie Street. This case is similar to the last one that we heard regarding an STRO permit. There are some factual differences to this case, though. And I have some documentation. I apologize, I didn't make enough copies, but if you'd like, I can pass them up after I discuss them. In December 27th, a letter was sent out by Metro Codes regarding the improper STRO or Airbnb at the 2311 Maddie Street location. I believe during the Christmas and New Year's time, Ms. Bell was out of town and did not get that letter until the beginning of January. As soon as she got that letter, she did her own research, realized that she had to have the permit, and went to Codes to obtain that permit. What she did after that is had the fire inspector come and look at the property. There's also another inspection done of the property as well before she actually went to Codes to apply for that permit. During that time when she was going through the inspection and application process, she received a summons from environmental court. I believe that was served on January 14th of this year. In between the time that she would receive the environmental court summons and the court date, which I believe, if I remember correctly, was mid-February, she actually received her short-term rental permit on January 30th of this year.
Mr. Wren, I just want to make sure the environmental summons she received was related to the short-term rental permit.
That's correct. And so it makes this one a little bit interesting because she actually went, got her permit, received the permit, went to environmental court on that date. She had to pay a $50 fine, and a judgment for Metro Codes was issued against her. And at that point, she had her permit and thought that she was good to operate. It wasn't until February 23rd that a letter was sent from the permit office that her permit was being revoked. That's when she got in contact with my office. I read the letter. We issued this appeal. And during that time, she received another letter in the beginning of March stating that her permit was being revoked. And at that time, I had tried to get in contact with John Michael to ask whether or not the appeal stayed the revocation. I didn't find out until today that it did not stay the revocation. So during that time, Ms. Bell thought that she had her permit. We thought that we appealed and that it stayed, but she was operating under the thought that that appeal stayed it until we got a decision from the board. Again, much like the last one, she found out that she was operating without a permit, tried to take the steps to get the permit, and actually in this case did get the permit. And it wasn't until she got notice that that it was being revoked that she wasn't entitled to that permit. And of course, that's why we're here today.
So, I'm sorry. Well, I'm just a little confused. So, the environmental court summons was because she was operating without the permit?
Correct.
And when was the permit?
I have a copy of
when was the permit itself issued? I'm sorry.
The permit was issued January 30th of 2017.
Okay, I see that. Okay.
And then the environmental court summons was served on January 14th. The court date was entered on February 15th. And then on February 23rd is when she got her notification from Metro Codes that the permit was being revoked. And of course, at that time, she got in contact with my office. We issued the appeal because at the time when she got her permit, she continued and continued booking. And so it created some confusion on her part as to, I have this permit, now they're telling me that the permit is taken away.
So it's your understanding then that when your client received the permit on the 30th, that at that point, Metro Codes thought she was in compliance and it was acceptable to issue it, and then the revocation was because of the pending
Metro,
Environmental Court.
that's correct. And I haven't
So
seen that.
she's in compliance as far as all the requirements to get the permit.
Correct.
But it's your understanding that the error was that there was a pending case and it shouldn't have been issued?
Correct.
Okay.
Correct. So, and I just haven't seen that happen before. And of course, Ms. Bell wasn't sure what to make of it. She got the notification, got the inspection done, which I have copies of those as well. The application for residential short-term rental, the inspection report by the fire marshal, and then, let me see, was this a reinspection as well?
Had to come back.
And I make these available for you all if you want
So-
to inspect them, but
I don't want to muddy the water. I hope I'm clarifying here. Was there ever a time in your client's, in your opinion, that you were ever operating without a permit?
there was. When she received the notification, and in full disclosure, Ms. Bell has been renting out the property, I believe you said since end of last summer. And she received this notification. It was sent end of December.
Right.
But she did not receive it until beginning of January.
And so the narrative that I'm hearing is that is when she started the process to get the permit.
Correct.
So on her side of things, from when she finally did get the notification in January, what was the status of, were there bookings made, or were there reservations on the books, and did she continue before the permit, before the 30th? And I guess the month of January, where are the rentals, and are there rentals booked?
Sure. During January, were there
No.
rentals booked?
No, I blocked it all off.
Okay.
'Cause I
And
didn't
there's
have-
none booked now?
There are
No,
there
there
are
is now.
booked now, and because when 30th, when she received the permit,
Okay.
at that time she thought it was operating.
So not from, okay.
Yeah, and it this time, because based on my mistake, I thought when there was an appeal that the revocation would be stayed, and so we thought until there was a determination today that that permit was still in good standing, and for that I apologize, because that is my mistake. Ms. Bell also has her tax compliance reminder that she does know about that. And then, much like the last case, Ms. Bell is a highly regarded Airbnb hostess. She is a 5-star, I guess, reviews in that. I do have copies of her guest book and some of those reviews too. Whether or not that makes any difference to the board, I'm not sure. So.
Is this an owner-occupied home?
Yes,
So this is your home?
yes, sir.
So your argument, Mr. Wren, is that this is a different situation from the last case because your client did not book the property until January 30th when she had a permit in hand.
So she was improperly booking before.
I understand, but
Yes.
once she realized that she didn't have once she got the letter that she didn't have the permit, she
Correct.
stopped booking. Is that correct?
Correct.
And what day did she call your office?
This would have been after February 23rd, because that is when the letter was sent out. So it would have been late February or very 1st of March.
Okay. And then the 9th is of March is when she came to Codes to appeal.
Correct.
Okay. And so, yeah,
Well, according to the letter from Metro, she got a 15-day letter, so she would have been lawful until March 9th or 10th anyway, under this letter. But I have well, maybe we should, I don't have any other questions for the applicant. I have some questions about the process.
Are there questions, any other questions for the applicant right now? Do you have anything more you'd like to add?
No, just that I think it's kind of a unique situation because she received the permit in error. And I think if she never received the permit, then this would be a different case. And I think we could look at her intent if she was still booking after a permit was denied. This issue is different. She was given the permit in mistake, and she is, to her detriment, relied upon that for a period. And of course, if she had known that she wasn't supposed to get it, then this would have been a different issue.
Any other questions? Anything else?
That's all. Thank you.
Okay, great. Thank you. We're going to close the public hearing and we will discuss.
I had a question. I don't know if this is Mr. Herbert or Mr. Michael, but is there a question asked when a person comes down to get their permit whether or not there is an environmental case pending?
So there's not a question asked because our CityWorks software program typically includes a flag that expressly identifies, hey, there's an environmental court case pending, or an RFS case. That's how it's coded in our system. As a result, the zoning examiner who takes the short-term rental permit application sees that right at the top of the screen and knows, oh, wait, I can't proceed. The error made by the codes department here is there was no such flag, despite the fact that there was, in fact, an environmental court case. Simple error in terms of data entry, and it's, although relatively unique, as Mr. Wren has accurately stated, it is far from unprecedented, I'm sad to say. We've been down this road more than once before. I think it's important to clarify then that the portion of time that staff regards board to be interested in here is before receiving the notice from the codes department of the whole, you're operating without a permit, that's illegal, get into compliance. That's something you're interested in, and that alone would have brought this case to the Board of Zoning Appeals if there was to be a permit issued. As to the period of time where the applicant came in, properly applied for a permit, was mistakenly given a permit, we are not interested in seeing her punished or in otherwise harshly treated because of that period of time. She thought she had a valid permit after all. But then there's the period from the time that we canceled the permit. You referenced the February 23rd letter. The follow-up letter actually went out on March the 13th. So from that date forward, there would be responsibility for whatever actions have taken place in that regard. Again, that's how staff views it. The intervening time, issuance of permit to notice of the cancellation of the permit, we're not looking to make any trouble for the applicant with regard to that period. Council stated it correctly. She thought she had a permit at that time.
I mean, I'm still confused about the how we parallel the environmental court. Is there always an environmental court case?
Not always is the short answer, but council, who handles a lot of these items, can actually address that more clearly than I can.
There is not always an environmental court case.
Why? Or why not? I just don't understand why some people, what triggers the environmental court that is different from us?
Well, for one thing, cases are before the BZA because the applicant appeals. Environmental court, this is Metro finding, either receiving a complaint or on our own finding a violation and pursuing it in environmental court. The distinguishing factor between the two cases is that the BZA considers item A appeals for denial of the permit. And as y'all know, y'all are looking at whether or not the zoning administrator acted in error or arbitrarily in denying the permit. And y'all have up to a year. In environmental court, the judge is looking at whether or not there was a violation of the code. So it's two different issues, two different penalties. One, the applicant is coming to you of their own volition because they're appealing, and one is Metro saying, we see a violation, we're going to file a warrant.
So if it comes to us through a complaint, if a neighbor complains, it goes to environmental court, they may come to us, or it might be cases that we've heard where someone who's renting finds out they need to have a permit, goes and tries to do the right thing, never got cited, and then comes to us because they had admitted when they were there, or the codes administrator looked up on Airbnb and saw it was rented and said, there's your advertisement, you're breaking the rules, I can't give you a permit. So that's why you might come to us without going to environmental court, is because you never had a complaint against you.
Or if the city didn't, again, it codes is to a large degree a complaints-driven department. So if they receive a complaint and Property Standards investigates and finds a violation, but sometimes through their investigation of one property, if the inspector comes upon another property that is advertising or operating without a permit, he might, separately file a separate warrant on that property. And again, it wouldn't necessarily come before the BZA unless the applicant's permit is denied and they appeal that to you.
But for purposes of us making a determination of what the applicant knew or should have known, or whatever our determination is, she would have known, even before she got this February 23rd letter from Metro, she would have known that there was an issue because she had already gotten served from environmental court.
My understanding, and correct me if I'm wrong, Mr. Wren, but my understanding is that the environmental court case by that point was closed. After the environmental court case was closed, she came in and applied for a permit, and the permit was issued in error.
Okay.
Is that correct?
The notification that there was a code violation was received in early January. And at that point, she started the process of applying to get the permit. On January 14th, she received the summons from environmental court. January 30th, she got her permit, and February 15th, the environmental case was closed.
Okay, so she did apply before the environmental case was closed, so,
It clearly was the missed flag.
right.
So this is another how the gears work kind of question, and we may have talked about this last meeting here at the board of STRP, but when we find that or when we give an issuance date for a permit after it's been appealed, when does the 1-year clock restart then, or does it start from when they initially applied? How does that work? Because these are all, no matter what type of STRP, it's always a year. So how does the clock run once we give a date?
Let me look and see if the ordinance says anything about,
While she's looking that up, any thoughts on the case?
I have an answer for you, unless you want me to
No
wait.
time for thoughts, we have an answer.
The ordinance says that there shall be a waiting period of up to 1 year from the date of such a finding for the property to become eligible. So that would be the date from the finding by the BZA. Up to 1 year from the date the BZA finds there was a...
But the new permit is good for 1 year from that date. Is that what I was asking?
I'm sorry, I might have misunderstood.
Yeah, I was looking at the other side.
Oh, of how good...
How long did they get the permit once we give a date? Is it from when they started this process or from when we say, now you can get a permit?
I would say it's...
I can actually jump in on that part. I misunderstood, and I think council may have as well. I thought your question was, how long does the 1 year inability to apply for a
usually
permit
ask such
run, and
clear
it counts
questions.
from the board's determination. To your flip side of that question, how long, it's a 1 year permit.
Okay.
So whatever date they get the permit, it would be a 1 year period.
Okay. Sorry about that.
Yeah, and I do see some similarities between this one and the previous one. It's the second case that I can remember where we've had someone who believed that the appeals process was, that everything was okay, when you appealed, we've had a homeowner, and now we've had a homeowner's representative with that. So there seems to be, I think it reasonable that someone might think that, but that said, it's not the perfect case, and so therefore there should be some
Right,
penalty.
and along those lines of thinking, I sort of, that's why I was trying to put together the timeline in my head and make sure I understood it. I'm actually pretty forgiving from the time when she originally got the permit. I would entertain a small delay in getting the permit just because she did, but she did have some bookings after that. But I don't think it was flaunting. Like we had one case in here where the guy was like, I'm not going to lose my bookings. he was sort of playing, I'm gonna ask for forgiveness rather than permission sort of attitude, which sort of I thought was the wrong way to approach it. So, I mean, if anything, I would be looking at minimal, if any, additional time on the delaying the permit. It's just because we hear a lot of these cases, and I'm always a little surprised when there's something new. And this is similar, but yet another wrinkle in what seems like a fairly straightforward ordinance. So I'm actually pretty understanding of the situation, and I don't know that anybody with the right intentions would have played it any differently than this this appellant. And I don't know that this attorney would have done it any different. And I certainly think that as an officer of the court that he was doing what he thought was right, and I think seems legitimate to me. That's where I stand on it. I propose that you make a motion. Well, I guess I said all that as a preamble if anybody else was going to say, well, we ought to at least give her a month or something. I mean, if no one feels like there should be an additional time, then we go with the time served.
But has there been time served since nothing happened? That was kind of that's the only thing. I mean, I think there was thoughtful and logical advice that was wrong, given, which was, hey, in the appeals process, you can keep doing what you're doing.
And it was professional advice. I mean, it's
right, and that's what I meant.
Yeah, I mean, it's who you're supposed to listen to, and I again, I don't think there was any malice on anybody's part in any of this, which is why I'm feeling generous.
Well, I 100% agree, and I don't, like I said, I don't think in the first case, and again, every case is different. There was malice, but at the same time, there wasn't any time at all that other than the evidence that was presented, which I think is supporting the applicant, that during that time when there wasn't a permit, that said, okay, I don't have a permit, I'm not renting. January 30th, got the permit, started up again, and I think it's certainly beyond fair for the applicant to think that she did the right thing. If you go down and get a permit, they say, I mean, I don't have an issue with that at all. It just really is it 0 or a month or whatever, and
I'll, like I said, I'll accept anything up to a month, including 0. I mean, I'm okay with no additional time. If somebody wants to make a motion.
I'm not going to make a motion, but I do want to say for the record, the only reason I agree with what everybody is saying, and were this applicant here on her own, I would feel a little bit differently about the lack of knowledge of whether the appeal stayed the proceeding. So I feel like she relied on advice, and I don't want to punish her for that. But I would like somebody else to make a motion as to what the appropriate punishment, if any, should be.
Well, I'm unclear on something. Was the property rented between the January, and do we have to open the public hearing for me to ask them the question? Okay, I'll ask you all then. Between January 14th, the environmental court summons, and then mid-February when it went to court, or even the January 30 when the permit was issued, were there any bookings during that time?
Yes, she thought she had a permit, and she did.
I thought the testimony was that when they got in the environment between the 14th and the 30th, there were no bookings because
that's right.
From environmental court saying, hey, you're in violation, right, until the 30th of the permit. I thought that was the testimony.
That was my understanding, and then she booked beginning.
But once you got the permit before environmental court, but she had a permit in hand, she started booking again because she had a permit in hand, and who wouldn't think you could do that, right?
So in other words, she did not have any bookings during January 14th through January 30th, so she did try to do
that was a
right.
testimony.
That was my understanding.
Okay.
I'm easy. I can go either way on this.
All right, I move that that we find that the zoning administrator did not err in his decision, and that the applicant is, why do we stumble right here? Is eligible for permit as of today.
There's a motion. Is there a second to that motion?
I second.
Okay, we have a motion. We have a second. Any discussion? All in favor of the motion, say aye. Any opposed to the motion? Motion passes 5.
With that, the permit will be eligible for application probably as early as tomorrow if you all want to come down. We always recommend people come very, very early.
Thank you. Thank you very much
Thank
for your
you.
time today.
Okay.
Mr. Chairman, the next case to be presented to the board is case number 2017-093. I know that it will excite all of you to know it is a zoning case. This is a request for a variance from front and rear setback requirements in the RS 7.5 zoning district, specifically at the property identified here on the zoning map as 505 Sarver Avenue. It's in Council District Number 9, up in Madison in the Amqui neighborhood, just not too far across the street from the Amqui School. Robin York, the appellant on behalf of Red Group, owner of the property, files this appeal requesting both front and rear setbacks. The aerial photograph here is a bit dated now, but nevertheless shows the vacant lot where they intend to build the single-family residence. And the site plan submitted gives some idea of the layout of the property, its unique shape, the orientation of the subject property, and the setbacks required and the setbacks requested. Mr. York, if you're present, please come forward to make your desired presentation to the board. Mr. York or any other representative of Red Group? Going once, going twice, no dice. Mr. Vice Chairman, I invite the board's direction as to whether to deny the case or to continue to, or defer rather, to a later date.
This is the first time, so
I'll move that we defer one meeting.
okay.
I'll second.
There's a motion and a second to defer this case one meeting.
Is that okay? Or
2 meetings?
I'm sorry,
The board's
I meant-
docket is especially packed for May the 4th. The board
I'm
may
sorry,
find
I
it
meant
much
to
more
say 2
expedient to
meetings.
hear this on May the 18th.
Is that okay with the second? Okay. This,
I'll second that motion again.
so there is a motion and a second to defer this to the second meeting of May. All in favor?
Aye.
Any opposed? This case is deferred.
And Chairman, could we take a 5-minute recess, please?
Is that okay?
Board will take a brief recess
Take a
before
5-minute
reconvening for
recess.
case number 94. At this location has filed an Item A appeal challenging the denial of a short-term rental permit, denial having been based upon prior operation before obtaining the legally required permit. Zoning map here shows the subdivision in question, R15 zoning district. Aerial gives you a little better view of the neighborhood. And although that is a dated picture, that is a picture of the property.
John Michael?
Yes.
I'm sorry, our reporter's not back yet.
With that, we will hit pause until we have a court reporter to record our proceedings. Sorry for the delay.
Please get comfortable.
Is there anyone here in opposition to case number 94? Seeing none. When we reconvene, you'll have 10 minutes to make the desired presentation to the board. And that'll be just a couple of minutes.
Wasn't able to go, but I was given information that I needed signatures that proved that I had made my neighbors immediately aware of my intention to use a short-term rental property. So on on February 28th, Tuesday, I got in line again after I had obtained, if you look at the map, I'd obtained the 3 neighbors that are right next to it. I'd obtained their approval is not the word. It's the Acknowledgement.
They're aware of what you're doing.
Yes, they're aware. I have a piece of paper that I think is part of the record, but that I had gotten their not approval, but their awareness. And then I went back into the office, and it was on February 28th. I was too late to get into the line. So March 1st, I tried to join the line again, and it was at 9:02, and they were closed. And so I learned that you have to do it almost immediately to join the line. So March 2nd, which is a Tuesday at 7 a.m., I got in the line. I went in there. I met with the administrator, and he told me that I needed to have proof that I had made aware the property that was behind my yard, which is a wooded area. And I didn't know who the owner was, but I got that information, and I sent him a certified letter. And then also the apartment complex, which is, if this picture, that last one that's not actually the property. It's the one just to the left. Yeah, that one, that borders the apartments and that rear property. And so I left the office and went back and sent the certified letter, and then went, and each time that I went to the zoning administrator's office, I brought my information, and I brought proof of insurance. And at this time, I hadn't rented at all. I was just attempting to get a permit. I hadn't done anything like that. And I went and I brought my insurance information, which the zoning administrator wouldn't look at. He wouldn't look at any of the information until I had it all in order. And so then, after I sent the certified letter, I went back in. I actually took a picture of the lady at the post office with the certified letter and went back in, but the certified letter had not been delivered. And so, again, I had to come back to the office. And so I went in again after the certified letter had been delivered. When I was there originally, and I tried to show him my insurance, he asked if I had proof of insurance, and I said I did, and I had it right here. This is what I printed off on the 24th of February, and I tried to show it to him, and he said, I don't need to see what you brought. I can look it up if you have an active listing. And so I thought, or I was led to believe that I thought I had to have an active listing. And so when I went back in and I had all the information and everything that I've been given, I had rented. I had 4 different rentals that had been in there in the space of this time between March 1st to March 13. And then once I found out that I had someone rent my property and I was in violation, then I stopped and I canceled the listings. I removed the listing, and then and this is why I'm here for the appeal. So I would not have rented had I not thought that I didn't need, I wouldn't have rented if I didn't think I needed an active listing. But I was led to believe that I needed an active listing in order to have my insurance information. And since then, I haven't, and I canceled the listing, and I'm waiting on the appeal.
How many times did you actually rent the property?
4.
You're saying you rented it 4 times between March 1st and March 13th?
Yes.
And you had not rented it previously?
No.
And what led you to believe you needed a permit to begin with?
When I went to the zoning administrator.
Why did you go to the zoning administrator?
I went to the zoning administrator to obtain a permit.
Why did you think you needed a permit?
Because I went online and I was looking, and I thought Airbnb, in order to do it, you have to have a permit, you have to have the city's approval for what you want to do. We've lived in this property for 12 years, and we have 4 boys that we've raised there, and so we wanted to obtain a permit legally. We know all of our neighbors, and so that's why I went into the zoning administrator.
So do you currently live in this home?
We currently, no. I have all of my couches and everything is there, but we're staying with a friend about 10 minutes away.
Mr. Chairman, I just want to clarify something. I've never met with Mr. Williams, so he's saying the zoning administrator, but let's be very, very clear for the record that it was probably zoning staff.
I appreciate that. Yes, thank you.
Okay. And there may be a little confusion because all these item A's are saying are saying you did something, but it really is the staff and whatnot. So thanks for the clarification.
Yes.
So I guess the question I have is, we have a letter from Councilmember Dowell that said, I guess it in part says that we should deny the appeal because from the conversations that you all have had, Mr. Williams knowingly rented out the property as a non-owner occupied rental without a permit. So, but is that, what conversations did you have with your
I had one
counsel?
conversation with Jacoby. I apologize for cutting you off. I had one conversation with Jacoby. It was yesterday. And I called her because I just wanted more information on what to expect in going to an appeal hearing. And then in conversing with her, when I was talking with her, it seemed to me that she was vehemently opposed to any kind of an Airbnb or a short-term rental property in any kind of an area in the council. I looked up on, and when I was having a conversation with her, this is what prompted me to go to the website, which is the council website, the city website, and there are 0 permits issued for a 31 permit available area for Rice Hill Circle. And so when I was having my discussions with her, I said, there is nobody where I am doing an Airbnb. And I feel like the neighborhood has actually come back since, there was a lot of negativity that happened with the closing of the Hickory Hollow Mall and lots of those shops closing. And there was a lot of negativity towards Antioch and things like that. But I feel like Antioch has come back and that it's really started to improve. And so in my conversations with her, I said, I think that this is a good thing for this economy because these people will eat in the restaurants locally, and they will, go downtown and do all these kind of things.
Okay. And so you did state that you as soon as you were denied, you took it off the listing. It's not listed now.
No.
You didn't rent it again.
Right.
Okay.
I have a question, Mr. Vice Chairman. I also live in Antioch, and I agree with you that indeed we are coming back and
Yes.
have made a great comeback. I noticed that Councilwoman Dow says in her letter that she has hosted several meetings discussing short-term rentals and that everyone is knowledgeable. Have you or your spouse attended any meetings that she had that talked about this?
I have not attended those meetings. However, I have spent time in my neighborhood. I actually have a petition that I went around to each one of my neighbors. I have 16 signatures, including the president of the homeowner association and another board member from the homeowner association, that this petition states, and I can give you this copy, that I plan on, this is my property, and I'm maintaining the yard. I'm very good friends with each one of the neighbors on either side of me, and they have my cell phone number. They call me if there's a problem. If there's anything going on, I'm there. And so I got their signatures stating that they are not opposed, that they're actually in favor, and that they have no problem whatsoever with me using it for a short-term rental property.
Yeah, if you could pass
Yes.
that here and make that part of the record, that would be helpful. Are there any more questions for the applicant?
I'm a little curious about what might have been said that led you to believe that you needed to violate the law in order to get your permit.
Well, he said that I needed an active listing. In order to look at my insurance, because I brought the insurance and the information that I had from it, like this, because I had created an account, but I hadn't rented.
Does that really make sense to you that somebody's going to say, here, you need a permit to do this thing, but I want you to go ahead and do it, and then I'm going to give you the permit? Did that make sense to you?
No, it did not.
Okay.
And so what I thought was, if the listing is active, that it would be able to have that I would be able to have the insurance information. And so I thought, okay, I created the listing, I made it active, and because of the popularity of Nashville, it immediately, like within an hour, had a booking. And so then, from the time that I went back and I tried to give the information and all the times that I was trying to obtain this permit, that's when I had the 4 rentals. And then immediately when I was denied, that's when I stopped, canceled, right. It is not.
So to clarify, between the 1st and 13th of March, were those were the actual dates that people were in the property and they rented it?
No.
That's when the reservations were made, or?
Oh, I'm sorry. I don't understand your question. Say that again.
You said between March 1 and 13th, there were 4 rentals. Did I hear that right?
Yes.
So that's when the people were actually at the property renting it? That's not?
Yes.
Okay.
Yes, because like I said, when I listed it, it was like almost immediately that someone wanted to stay there.
Any more questions? Is there anything else you'd like to add?
I have one.
Oh, sorry, good.
So when someone books a rental, do you have the opportunity to deny the rental?
Yes, you can.
Okay.
Anything else you'd like to add?
I would just like to add that we tried really hard in the beginning, and we did kind of mess up with listing it for the few days that we did and getting that, and we apologize for that. We did try to, and we are trying to currently do it correctly and the way that the city would have us do. So, and again, this is our home and all of our things are there, and so we want to make sure that it is taken care of, and we will definitely be on top of that in our property. So.
Okay, I'm sorry, can we get your name for the record, please?
My name is Christy Williams.
Thank you.
Thank you.
Any other things to add? I'm going to close the public hearing and is there anything from staff that in the record that we don't know about?
The one thing I would note is that we always check on if anybody chooses to use the Airbnb insurance as their insurance coverage. That's what we are able to see on the listing if, in fact, they make it an active listing. As the board has already made clear through their questions, the answers they receive, that doesn't mean you have to go rent it. In fact, you should block off the dates so that it can't be rented. And when rentals are booked, nobody pushes through the doorway and overtakes your home on 4 separate occasions and leaves pleasant reviews. You let them in. So
you can
active listing is not the same as advertising available for rental, which is what's the violation here.
Okay.
And
But having an active listing,
it's basically having an account, and an account where staff would be able to see that you have the required insurance if you choose to use their insurance.
all right, so that, okay.
And of course, for cases where somebody uses their, local State Farm agent for their insurance, that would never be an issue because you wouldn't have to see that active listing to see Airbnb's insurance.
Okay. Any thoughts? I mean, the letter from the council lady was certainly, when you get something like that, it's a concern, but I also understand from the testimony that there may be a general.
I happen to be acquainted with many of the people who signed this letter, and I have great respect for the ones that I'm acquainted with.
Well, and that was kind of my point in this neighborhood, this specific neighborhood, to have that many people say it's a need and we would like to have it, I think is something that bears a lot of weight.
I would agree, but I still think the fact that it was rented, I don't think it was rented properly. I would be in support of a 30-day or waiting 30 days before they can apply.
From the date of the last rental, the 13th, or that would make it?
I say 30 days from today.
Yeah.
I mean, we've got to get this process. We've got to get people on board with how these things work. So I think, to me, 30 days from today is appropriate.
Right. Well, and I will say the one thing, when I look at it, and I haven't been to Airbnb to the site. I know there was a long time when we had cases that said, man, if you even went there and put your name out there, then you were in violation. And I don't know, maybe the older I get, the less technologically savvy I feel, but I do see that I could go and create a site for my home and have it be active and not really know that you could have said no. But I haven't gone through that process. It may be very clear and easy. It may not be clear and easy. I don't know. But when I heard that that a proof of insurance could be having that account available, it did make me at least understand, the appellant's story, and I think that the only only 4 rentals is, I think, a fairly minor violation. So I don't know. I really want. I agree. I'd like to have all these, hear all the different versions of it so we can know, hey, this is the category, could go a little faster and that type of thing. But I think to me, with the neighbors and with the story,
Do you think 30 days is too much, or?
Yeah, I mean, I really don't have an issue with it going sooner personally, but like I said, I can go with the majority. But
Well, we're grasping sometimes. We want to have a well-reasoned process and discussion, at least on the record. If nothing else, in our discussion, we've tried to do that. And, I think in this case, he rented it for 2 weeks, so let's maybe defer it, or his eligibility for 2 weeks. That's not a month, it's 2 weeks, and in the big picture, it probably doesn't, I think it's defensible.
Would you like to make a motion?
Are there any more comments, or did you? I move that we find that the zoning administrator did not err in his decision, and that we find that the applicant is eligible for granting of the permit 2 weeks from this date. And he, assuming the applicant will be in compliance at the end of that 2 weeks.
And I second that motion.
We have a motion and a second. Any comment or conversation?
Is legal okay with that motion?
Okay. All in favor, say aye. Aye. Any opposed? That passes 6-0. You're eligible for a permit in 2 weeks, as long as you don't rent it between now and 2 weeks.
Mr. Vice Chairman, the next case to be heard by the board is case number 2017-097. Ben Derricks, the appellant, on behalf of Scott and Allie Greer, the owners of the property at 178 Kenner Avenue. The request is for a variance from the side setback requirements at this single-family property zoned R10 in Council District number 24. The side setback required at this location is 5 feet. The request is to reduce that by approximately 2 1/4 down to 2.74 for the full 30-foot length of the addition, or the proposed addition, to the single-family home. The site plan shown here gives a layout demonstrating the placement of the build-out. From the recent site visit, the property from the street, the view across the street, the views up and down Kenner at the subject location. Because there is opposition present, both sides will have 15 minutes to make the desired presentation. Because this is the first time it's been applicable today, I should make note of the fact that that's a collective 15 minutes for those who are here in opposition. Not everybody gets 15 minutes individually. You get to share it. So carve that up however you see fit. If Mr. Derrick or Mr. and Mrs. Greer choose to come forward at this time and make the desired presentation to the board.
John Michael, I'm sorry if you said this and I missed it, but is this a situation where it's an existing non-conforming? Is it not already over the? Or is that better left for discussion?
What are you asking? I'm asking
Well, see, it's already over. The existing house is over. And their addition may be over as well on the side.
Yeah, I mean, it's a side setback, so you're saying this part is already too close.
Yeah.
Mr. Harper, although the appellant is in the best position to speak to the particulars of the site plan as proposed, it does appear to be a mere extension of the existing placement of the house at this location. And thus, if that were the case, that would represent a legal nonconformity that's already in place.
Okay.
But again, better for the appellant to have the
I just
opportunity to
wanted to make
describe
sure I
that to you. As a reminder, the appellant will have 15 minutes collectively to speak to the board on the subject. If you wish to save some portion of the time for rebuttal, you should save it out of this originally allotted 15 minutes. Please introduce yourself by name and address.
Good afternoon.
You can push the button and turn your mic on.
Thank you. I'm Charlie Rankin of Rankin Design Works. I'm the architect on the project and here on behalf of Scott and Allie Greer, the homeowners who are here in attendance, as well as Ben Derrick of Bryan and Myers, who has filed the appeal. They're the contractors for the project. And as was mentioned, we're here requesting a side setback variance for 178 Kenner. It's a Tudor-style cottage built in 1948. As mentioned, R10 zoning, 5-foot setbacks, and the proposed addition is 16 by 30. And to answer your question, that the existing house is already non-conforming. Our proposed addition would simply align with the existing side of the house, encroaching no further on the property line. The existing outside corner is at 2.74 feet from the property line. Given the relative narrowness of the lot and the house and certain floor plan restrictions on the left side of the house,
moving the proposed addition towards the center of the house severely restricts the possibilities of any sort of addition onto the existing house. Furthermore, you'll notice that vehicle turn-in area from the shared driveway to the left side of the property and existing detached garage further restrict the homeowner's ability to move the addition any further in from the property line. We are requesting that the proposed addition be allowed to align to the existing right side of the house with no further encroachment towards the property line. We feel the proposed addition is consistent with the original development pattern of Kenner Avenue. First, there would be no change to the overall width of the house. The existing house is 39 feet, 11 inches wide, which would fit within the prescribed building envelope were the house not shifted to the right side of the property. Secondly, we've taken great care with the architectural design of the project to respect the historic nature of the house specifically and Kenner Avenue as a whole. By locating the proposed addition to the rear and behind the existing house and minimizing the height such that the addition will be no taller than the existing house, we think we are proposing a solution that allows this beautiful old home to maintain both its historic charm and remain relevant to modern living standards. Although the project would require a side setback variance, we feel that the proposed addition causes no further harm to the neighbors, given that, as mentioned, the existing house is already non-conforming. To that end, I'd like to note that the homeowners have received signed letters of support that I have with me today from neighbors on both sides, both 176 Kenner and 180 Kenner. And the neighbor Drew Robinson from 176 Kenner was able to be here in attendance too to speak in support of the project. We appreciate the board's time and would ask again for your consideration of the hardship created by the original 1948 house being located within the current side yard setback.
Is the addition one story?
It is a story and a half. So there is an upstairs.
In the gable?
In the gable, yes.
And it does not exceed the existing house?
That's
the
right.
Main gable?
The new ridge would align to the existing ridge, so no taller than the existing structure.
What's in the addition? It looks like a laundry room, and what else?
We'll do a kitchen renovation with a small, about 4-foot bump out closer towards the center of the house. And then the addition that is proposed includes a family room and laundry room and connection. We will end up connecting to the existing garage that's there. And then upstairs is the master bedroom, a new master bedroom.
If there's anybody else that would like to speak on your behalf, then they should do that during this time instead of rebuttal time, because if you don't speak now, you can't speak later. So just wanted to let you know that.
Okay.
If you had someone that wanted to say something for you.
I think Mr. Robinson would like to.
Okay.
Thank you. Thank you. I'm Andrew Robinson. I'm the neighbor to the left at 176 Kenner Avenue. I've been there for almost 20 years. We know the Greers well, and they're great neighbors, and we support the project fully in both scope. We're the ones affected, really. We're the construction will be on our side of, the trucks and everything will be on our side of things. We renovated our house 6 years ago, and we ran into a lot of the same type of issues. We were not in violation. Our house was not done skewed to begin with, or it was done skewed, and so but we were within the envelope, so we didn't have the same problem. So, Kenner Avenue has been really renovated over the past 10 or 15 years, and a lot of the neighborhood association wants people like Scott and Allie who are coming to keep the neighborhood preserved. Somebody came in and built 4 monster quadplexes in there not too long ago, and if we can keep that from happening, this is nothing. This is just minor. So we believe that this is going to be a good project, and we're intimately attached to it. So we've talked to the architects, and we believe that it'll be positive for the neighborhood.
Any questions?
Thank you.
Anything else you'd like to add at this point?
I would just, to piggyback on his comments, I mean, I feel like what neighbors are probably most concerned about is what we see on Kenner and a lot of the neighborhoods, historic neighborhoods around town, where people are tearing down houses and building, monstrous new houses, 2 houses on a lot, 4 houses on, a lot, what have you. We feel like this is a modest addition that allows for this house to grow to modern standards, to allow a family to live in it with a modern living sort of norms, without destroying the character of the neighborhood, without destroying the character of the house. And we feel like it's a good, it's a good scale for the project, for the neighborhood.
Thank you. Any more questions for now? When we will hear from the opposition, and you'll have 9 minutes and 48 seconds to rebut any testimony that you hear from them. So if we could have the folks that are opposed to this project come forward, and you can switch spots with them. If you don't have to stay there.
We can sit.
You want to sit? I don't mind.
It'll be really easy.
Okay.
So my name is Chris Ream, and I am the property owner at 247 Ensworth Place, so I'm right behind you guys. And we received the notification that you would be coming here in front of the board, and I think because of what was referred to earlier as far as what has happened on the other side of Kenner, we were worried. We saw 4 big houses coming up. Up against our backyard, and so I think that was the reason that because we didn't know what was happening, and so I was worried about the potential impact to my property and to those properties on our street, right behind my side yard, where the backyard. Where the back property line runs into, has a few houses on Kenner, and so if we were to have all of a sudden multiple homes that were ginormous all along the side of my side yard, it would be a really sad day for us. And so I'm excited to see the proposal as you've presented. I just would love to hear, it looks to me like you're going a little bit sort of back to where the garage is currently and not much further back, and I just wondered about that.
So the roofed part of the house extends to just beyond about the center point of the garage, and then you'll notice there's a small uncovered terrace to the back there as well.
Gotcha, that extends behind the garage a little bit. And so
Mr. Chairman, if I may interject here, completely appropriate for the opponents to speak, completely appropriate for the opponents to address the board. Be glad to take a recess if it's appropriate for folks to have a conversation to talk about the particulars of the project.
And I think really I don't have to.
This ain't board right now.
Yeah,
okay, sorry, I'm sorry.
Well, and it seemed, and then, sorry, I went away from the rules just a little bit, just because it felt like that you were getting to very quickly to a point.
Yeah, no, I mean, I don't really, oh, please finish what you're saying. Sir, whoever, I interrupted.
No, you absolutely were fine. Not a problem, thank you. But, so that was why I did that. So I think that if you have questions for us or questions that you would like for us to ask the applicant, we are certainly more than willing to do that if there are additional ones. But if, it did seem like, again, the cases that we like the best are ones where folks that are opposed come around to thinking, no, this really is probably a good thing, or with modification and whatnot. So did you have other things that you'd like to say?
Absolutely. No, that was just my main question was how far from the rear property line would the construction project go?
And we can ask for clarification, but I think that you all had a little bit of a discussion on that. So anything else that you'd like to add?
No.
Any other questions for the opposition?
So does that negate your opposition?
It does. Mm-hmm. I'm not very oppositional by characteristic, so that's really great.
Okay, great, thank you.
Thank you.
Okay, so we'll go back to the applicant and ask if you have anything that you'd like to add.
No.
Okay. Then at this point, we'll close the public hearing and remind the board that this was originally on the consent agenda because of the reasons mainly that the applicant had stated, and now that the opposition understands more about what the project's about and doesn't have opposition, then is there any discussion?
I can support the variance request because of the narrow lot and the position of the existing house on the existing property. And the garage and the existing concrete drive are being maintained, which I guess makes the buildable area more narrow, maybe more not, maybe the lot is not narrow, but the available footprint is narrow. So I could support the variance request. And if there's no more discussion, I'll make a motion to approve the variance request based on everything I just said.
I'll second.
We have a motion and we have a second. Any more discussion? All in favor, say aye. Aye. Any opposed? That passes 6-0.
Mr. Vice Chairman, the next case that the board will hear is case number 2017-101. This is the case involving Nashville Classical, the charter school in East Nashville. They are the appellant. Metropolitan Government is actually the owner of the subject property, located at 1310 Ordway Place. The zoning map here shows the R6 zoning district along that stretch of Ordway in a primarily residential neighborhood. The aerial map shows the subject property, and although this is somewhat dated, it does give a general sense of the orientation and layout of the school and their property, which goes all the way out to the street to the right there. The site plan submitted gives an idea of exactly where they want to have the proposed building, which is a temporary modular classroom for the continually growing school to be used for a finite period of time. The appellant and representative for the appellant will be able to explain that in greater detail. From my recent site visit, the straight-on view of the subject property and the primary school building that, of course, has been there for decades on end. The view up and down Ordway, as I said, a primarily residential street with prominent street parking. And then views of the kind of added area alongside the primary school building, generally showing, at least, from the outside of the fence where the proposed addition would take place. The appellant is represented by Mr. Hargis, Baker Donaldson. They'll have 15 minutes to make the desired presentation, and opponents will have the same 15 minutes thereafter. Mr. Hargis, although you may not need the reminder, we always like to remind folks you will want to save any time needed for rebuttal.
And I will need to disclose something first, is I accidentally spoke to some of the parents who are in support of the school, who have children at the school. But I didn't learn much about the case. I didn't know it was coming before our board, only that they support the case. So I wanted to disclose that. There's nothing that would keep me from being impartial.
All right, Mr. Hargis.
Hi, Mr. Taylor, members of the board, as John Michael said, I'm Joey Hargis Baker Donaldson. To my right is Charlie Friedman, the founder and head of school for Nashville Classical. I submitted briefly in the record just a memo regarding that essentially our school is not subject to zoning regulations per Metro legal opinion. However, I do that for purposes of the record. But we did come before this board and the Historic Commission in an effort to be transparent and work with the neighbors and talk. So I'll introduce now Mr. Freeman to cover a little bit about the project, and then I'll follow up. We do have one parent that is present that would like to address the board at some point. So with that, I'll turn it over to you, Mr. Freeman.
Great. Good afternoon. First of all, just thank you for the opportunity to speak about our school. I also want to thank Councilman Withers, even though he's not here. He was responsive, honest, transparent, really direct and clear throughout our process, and very helpful. I also just want you to know that I could probably talk about Nashville Classical and our school for days, but I'm going to be sort of careful to just give you some facts right now. So we're a free public elementary school that enrolls grades K through 3. We have a charter for grades K through 8. As a charter school, that means there are no tests to get into our school, and there's no geographic priority zone, so it does not matter what street you live in order to attend. We offer free transportation to all of our students as well. At our school, about 7 in 10 children live in poverty, half ride a bus, and they come from as far away as Antioch and Madison. And so in other words, we really represent the entire city. Except in some very key ways, we are different. Today, about 80% of our students are on track to score proficient on state exams, and about 50% are on track to score advanced proficiency. These results surpass the best suburban schools in the state. So in fact, while our school enrolls about 1 in every 50 low-income third graders in Nashville, we represent about 1 in 5 low-income advanced proficient students. Every student takes a foreign language, studies music, and enjoys enrichment opportunities that include chorus, computer coding, art, and sports. So we're not perfect, but we believe what we do is special, and what I just described probably sounds pretty good. So 3 things are true as a result of the fact that we believe we've built a really wonderful school. One is that students that come to our school don't leave. We have the lowest attrition of any charter school in the city and among the lowest of any open enrollment public school in the city as well. 2 is that applications are up. So we receive more than 5 applications for every open seat. We're the most popular non-selective elementary school, and we're committed to maintaining our diverse population. And so really, really just bluntly, we believe that when you increase scarcity, so you reduce the number of seats available at the school, you do not serve the neediest and most vulnerable children in the city. And so finally, we're running out of space. So when applications increase and attrition decreases, space gets squeezed. Even with the proposed modular, we'd have about 75 square feet per student. Other neighborhood East Nashville schools offer between 150 and, based on my most recent research, as much as 400 square feet per student. We'll have an additional middle school building in about 18 months. We hope it gives us additional flexibility and additional space. However, we need 4 classrooms by August and need to place an order with our manufacturer as soon as possible. And so we're asking to do something that schools across the city do regularly and all the time, which is build a temporary space. A little bit of background around what we did. The very first thing we did was seek out manufacturers that have worked within historic overlays and design structures that exceed what traditional district modular buildings look like. We worked with them to determine pricing, location, and feasibility as well. From there, we reached out to our neighborhood association, and they scheduled a meeting. We shared our current plans at this meeting. We brought the manufacturer to the meeting and solicited feedback. That was at the very beginning of January. Since then, we invited neighbors to tour our school. We discussed plans, participated in an interview with the local neighborhood newsletter. We met with neighbors one-on-one. We sent Facebook messages to people whose contact info we didn't have. We attended a general neighborhood meeting, offered to attend the neighborhood board meeting, hosted another meeting this week for neighbors as well. And I've tried to respond to any phone call I've gotten and shared my cell phone number with anyone who's asked for it so that we can respond to any concern along the way. We've tried to also summarize the feedback that we got at every meeting and CC our city councilman on that summary, just to be really, really clear that people feel heard. Some specific changes we've made from the original sort of proposal and suggestions of the manufacturer. We changed the location of the structure, moving it as far back from Ordway Place as we could. We changed the windows and the door material. We changed the siding material. We changed the location of the HVAC. And then we changed the layout of the parking and built plans to landscape in front of the structure to obscure any visuals on the Ordway side. Most recently, based on feedback we received, particularly from neighbors on the Gartland side of the building, we made a few other changes as well. So we shared that we knew there was concerns around traffic, and I'm happy to address those in more specificity if necessary. But we made plans to add an additional school bus, which would take about 60 cars off the road, as well as offering additional aftercare programs. We piloted aftercare for the first time this year, and we plan to expand it. And so at that point, we actually think there will be fewer cars on the road next year than there are this year. Our current parking plan, which is sort of a multiple iteration, actually adds striped spaces to the school, and so we're actually adding parking as well. And then we heard concerns around the alley usage, and so we've contacted vendors currently that don't provide food or milk to make sure that they know to make all deliveries on Ordway Place. And then we're designing a plan for next year where we'll create signage to really specify the use of both the parking lot and the alley for deliveries after construction's done. We've also contacted our dumpster company, and we've gone through several dumpster companies to make sure that they weren't doing sort of middle of the night pickups and things like that. And I know that those vendors have still not been perfect, and neighbors still have concerns, but I want to be really clear that we've tried to address those and address them directly with the vendor. And we want them to come and see if there's a way to get that dumpster even further away from the alley and away from houses. We believe that the way that the parking is set up could do that. We've also started to work with landscaping and designers to make sure that on both sides we're being thoughtful about trees and planting and things like that. Here's just sort of the bottom line. One is that we are a charter school, and so we're paying for all of this out of our operating budget. That means every dollar that we spend on siding, a door that's going on Ordway Place that is being done purely for historical purposes, additional money that we're spending on landscaping is money that we take away from children and take out of the classroom. We do not access the government, the Metro capital budget, and so again, all of that money comes from our operating cost. I also want to be really clear, I live on Forest Avenue, which is 2 blocks away from the school. And so I consider myself a neighbor as well. And so we're happy to do all of those things because we really do sincerely care about being the best neighbors we can possibly be. I think here's just sort of the bottom line. Our building was constructed in 1906, so I believe we're in our 110th year this year. At the time, Nashville schools would have been among the most segregated places on earth. And I think that that's probably just a fact that we all have to live with, which is part of our history. Today, bluntly, the data does not convince me that they are much better. And so I am so proud that our school reflects the diversity of the district, matching its free and reduced population almost exactly, matching its exceptional need population almost exactly. And we do that not through wiggling geographic priority zones, not through forcing families to come, but through offering a high quality education and going above and beyond to work with the city's neediest students. I think ultimately our schools touch on some of the most sensitive issues in the city: race, class, transportation, immigration, and growth. I sincerely believe that Nashville is a better place because of the children that are learning side by side in our school building and the work that they do every single day. Our school is home to 299 of the happiest, hardest working 5, 6, 7, and 8-year-olds in the city. Ultimately, I know your job isn't to evaluate the school, just the quality of our proposal. And so I want to be really clear that even though I think the law is a little bit unclear on whether we're exempt from these zoning codes, we've done every single thing we can to follow every code and guideline that we can. I think we've gone above and beyond what traditional schools do when they're running out of space in these situations. But if there is more that you think we can reasonably do, we are absolutely happy to do it as well. I think we come to this board with humility and with awareness that being a partner is really important. So again, just thank you so much for this opportunity and for the chance to, I think, give our 4th graders a place to call home and hopefully make the city a better place as well.
Great, thank you.
Mr. Chairman, if I can just briefly have a few moments to get in. I do want to say that it's our belief that this proposal complies with the ordinance. The Historical Commission has approved it for architectural compatibility with the neighbors, that we're not disturbing the natural features. The placement of this building was set on existing concrete that's there. The changes that we're making to the parking are a better improvement of what's on the site now. There's about 9 code compliant parking spaces. What we're proposing to do, you see there are 19. So it's not perfect, but it is better.
And is that for staff?
Yes, sir, it is. The zoning code requires staff, and as I mentioned,
can I actually just one thing I think that we want to do is in the signage specify that parking is only for staff. All deliveries go out front. Visitors park out front as well, and so to make that really clear.
So these aren't parents that are pulling in, coming down the alley. The staff are coming in. They're parking. When the day's over, they're gone.
Yes, sir. And then, as I said, I do have a parent here, Ms. Shani Dowell, to speak on rebuttal, is present as regards if there's traffic concerns.
Okay, cool. And a quick question, did you all have any, do you have any issue or concern with the recommendations that planning had made?
We don't. No, we appreciate those.
It sounds like in your proposal you addressed each of those, and
I do. As respect to number 3, I would respectfully disagree slightly with the Plan Commission. The Public Works Department has commented they take no exception to our plan, as you've seen there.
But the plan here is that if the limit were on the alley access were to staff parking,
yes, sir.
That's what you were.
I think the only exception there is we do have, and I'm aware that there is a hardship that neighbors face here, but the reason why we can't have parking sort of right behind the main building is that our kitchen is sort of in that area right there, and so there are sort of cold-to-cold deliveries that happen in that area, but that would be the only exception that we would plan for.
I have questions for zoning staff, I believe. I just want to be clear as to why we're here and or what we need to be looking at. It's a special exception that can come before our board because they don't satisfy locational or design standards. And we're specifically looking, I think I read that the lot was too small and the rear setback was not sufficient. Is that correct? Maybe Mr. Hargis can also.
Yes, ma'am.
if you'd like to.
I can, and those are the factors that bring it to this board. Item 6 of the, strangely enough, the schools are permitted with conditions use in this zone district. When you read through it, if you meet all the conditions use permit. Number 6 is actually the opposite, and it says, if a school does not meet these requirements, you may petition the Board of Zoning Appeals only to the general provisions of 1716-150, and that is what brings it to the BZA. Any deficiency in the standards under the PC section, bring it here. And I just pointed out for my filing there are two, clear, obviously lot areas.
And so the rear setback, when the permit was applied for, it says required 50, proposed 35. However, your plan here says 47.5.
It's greater. The confusion in that, back last summer, the applicants made a filing for a building permit. The building was larger in size, in depth, length, as compared on the site plan there. This building's been reduced down to 64 by 60. And so the site plans that you see reflected on the screen there are the proposed site plans. So that's the difference in the two numbers that are there.
Okay, and could you also answer what's the required front setback? And I know you're not infringing on it.
Sure, no. The required front setback would be what the major collector street plan table is. In this instance, though, because it's a permitted with conditions used, schools are required a 50-foot setback from property lines, all property lines, for with any of their structures. So the setback would be 50 off of Ordway, too. But what brings it here is the fact that it's existing school with a valid UNO.
So how temporary are these? Or how long do you plan on
Yeah,
using them?
that's a great question. So with historic, they put, so the lease could have been, our lease takes us with the city on the building about 8 years with an optional renewal for another 8 more years with another 10-year optional renewal. The leasing manufacturer was sort of happy to lease it to us for up to 10 years. Removal costs are included in the lease. So I think one sort of like misconception that happens also is like transparently, sometimes at a district school, a portable will be put up and then it will stay there in perpetuity. And that's because the district purchases portables in bulk, and until they have another school to move it to, they kind of will leave it in place. And that makes sense, right? There are costs associated with moving it that are actually pretty significant. And so on our end, our leasing cost includes a removal cost, and we actually asked Historic to put a 7-year timeline on it as basically like a show of good faith to the neighborhood. Yeah, and we're putting that in here as well.
That's our request before this board.
Thanks.
Any other questions for the applicant at this time? Great. You'll have 4 minutes and 33 seconds for rebuttal.
Cool. Thank you. Do we stay? No. Okay. Sorry, I was like, do we stay here?
Okay, we'll hear from the opposition at this point.
Am I on?
Yeah, if you could just state your name and tell us
Yes.
your position on this.
My name is Chris Langino, and I'm at 1313 Gartland Avenue, right behind the charter school. So this, despite the fact that there have been so many community meetings, somehow I didn't hear about them until this week, and I was out of town. My husband attended the meeting. So this is my first opportunity to actually hear all the details of what's been proposed. And after hearing what I've heard, I would say I still oppose the site plan as proposed, but I would just suggest some modifications, which was mainly what I was going to do anyway. And so the modifications I would propose are requiring additional requirements to, require additional features to enhance the historic aesthetic of the modular building. From what I know, it's primarily a historic-looking door and windows, and if there's a way to do some sort of exterior molding around them that make it even more, because I did look at a lot of modular units online to see what they were going to look like, and of course I don't know exactly what ours are going to look like, but I think there could be the opportunity to make it a little bit more consistent with the historic character of the neighborhood. And then, and and I'm not actually sure if this is part of what you all do, but I'm going to say it just in the record, and plus because I haven't talked to the principal myself before. So I did see from the presentation he made at the community meeting that the school indicated that they will either replant or work around any trees to minimize impacts. So they're proposing taking out some, either replanting or working around trees where they're building the new parking area. From the research I did, I don't think that replanting the trees is an acceptable option at all, and it shouldn't be an approved option, and there's a bunch of reasons why. First, this needs to be done by next August, as I understand it, and the trees would not survive being replanted in that kind of a time frame. So what I see is that, what I learned online is that mature sycamore trees, which are these, that they're proposing to work around or transplant, have to be root pruned ideally a full year before they're transplanted. And at a minimum, they have to safely move them and increase their chance of survival, they have to be pruned now, root pruned now, and then not moved until the fall. So that would be after August. So it appears to me that just it's not even a realistic, viable option to transplant the trees. So it would be, I would love it if you all do this, if the terms of the approval of the special exception would indicate that they have to work around the trees. And, then there's all kinds of reasons why the trees are important. Shade, I mean, really basic. They're big trees. They have a big canopy. And it affects the kids', health and down the road because of providing protection from ultraviolet rays. It reduces their chances of skin cancer. I mean, that's long-term stuff. But, I mean, trees are really important just for that reason. Also, mental health, research shows that kids with ADHD show fewer symptoms of their condition with increased access to trees and nature. Beauty, trees will help make up for the unsightly new parking strip, which really is, for us right now, it's a beautiful green berm. It does have fence, but, it is green, and instead now we're going to have a parking lot there. So it would be, because we are directly behind there. And again, that's not just for our family, it's just people in general. Green is better, right? And then there's the urban heat island effect. Trees cool the parking lot and alley, and they contribute all over to, all around to a cooler city overall. That translates to reduced energy consumption and cleaner air and better health for everybody. And I can go on, but I don't think I need to. I think that I've kind of made the point that trees are really valuable for many, many reasons, and I really don't think it's a viable option to move them in the time frame that we have.
Can you tell us, I'm sorry to interrupt, but Can you tell us where the trees are? I can't see it on the plan.
So I actually brought pictures like that. But the trees that I think they're proposing to work around or transplant are at the back of the site behind the playground. So this is you can see how big they are. I mean, I can pass these up. So they're around the playground.
You can pass them to us.
Yeah. There you go. And then, I don't know how much time I've taken. Okay, I'll be really quick now. So the other suggested modifications I would make is that, since they will be removing that grassy berm to replace it with parking spaces, that they be required to use permeable pavement for the new parking area and also any other new hardscapes that they're putting in so that the runoff is reduced and water pollution is reduced and we have increased replenishment of the aquifer. And then I don't know to what extent there's going to be construction and demolition waste when you do a modular project. Maybe there's not any, but if there is, I would propose that they be required to use a waste company that recycles construction and demolition waste, because that's a really big thing. And I don't know if that's something that you guys address, but and then one final suggestion, which I'm just saying because earlier people were talking about the traffic and all, is that on Ordway, and I don't think you guys do this, but when they do pick up and drop off, they should have a no idle policy, because people are idling out there, which is just bad for everybody's health, bad for air quality, and it's a simple change to make. So that is the conclusion of my statement. Thank you so much.
Thank you, Chris. My name is Patrick Spence. I'm the homeowner, and I live at 1311 Gartland Avenue. My property backs up to the alley about midway where the proposed building will be built. Twice in the past, this is a 110-year-old building, the Metro government has looked at the property and seen it sort of unfit to have a school there. The first was in the 1980s with the original Ross School. It grew. They put portable or modular buildings out there, but eventually moved on to create a better structure a few blocks away. Then at the turn of this century, we had the Head Start program there. Same thing. The building itself, a pedestrian design building, was inadequate for their needs. They eventually moved to Frederick Douglass Park in a new facility. The current situation at that property, I think we mentioned earlier in the meeting when the council member was here, is traffic backs up for 3 blocks. It starts by the front door and goes back to Gallatin Road. Cars are double parking 30 minutes prior with their engines running. And we don't see this changing anytime soon. The commercial activity in the alley, we have, as the principal mentioned, our early morning, yesterday mornings at 5:41, when the trash trucks come to clear the dumpster, commercial vehicles making deliveries will back into the alley. This is an 18-wheeler. The pavement in the alley I measured around where my property is about 8 feet 7 inches. It strikes garbage cans, it strikes retaining walls, and then once it does park to make its delivery, it's blocking a carport at 1309 and also a garage at the house beside it while it makes its delivery to the school. According to the MNSPS website, Metro Nashville Public Schools, the current school there is at 108% capacity in the historic building itself. And the addition of this new classroom modular learning unit is not going to change that, because instead of taking children out of a fully packed, very old schoolhouse, they're going to add more children to it. So that situation will not change. It also won't change the traffic conditions on Ordway, and it won't change the traffic conditions for commercial deliveries in the alley. They will just increase as more and more students are there. And we'll also have the addition of deliveries plus employee parking coming and going in the alley. A similar school nearby, Laughlin Design Center, has the same population of students, around 300, as this current school does now. The addition will actually take this school up to 350 or more. Laughlin is in a building that is 3 times the size, on a property 3 times the size. It's a historic school building. But what they do, instead of adding more and more students and going above capacity, they limit the enrollment to what the physical structure can handle. And that's what we're asking here. We love having a school in our backyard. When I walk out in my backyard in the daytime, I hear children laughing, running, and playing. And if you ever lived in East Nashville, that's one of the best sounds you have. There's more negative sounds like Gallatin Pike or a restaurant or a shop or bar. But we get to hear kids happy. And we want our neighbor, the school, to stay there. We also want our neighbor, the school, to live within its infrastructure means and to continue to provide good education. I mentioned Laughlin Design Center, which is a public school, is at 100% capacity. The rest of our public schools are below capacity. Inglewood Elementary has 44% of its classroom seats, however you want to measure it, empty right now. Same thing with Warner. Both those schools are 5 minutes away, which the bus or the majority of the parents who drive to this school can easily obtain and go to. We're going to have this building for 7 years at least sitting there, and we're going to have the additional students, close to 350 if not more, attending a school that has been, again, proven 2 times that's really unsatisfactory in the modern world to be used as an education facility. And I want you please to consider the facts that if you approve this modular building, these 4 classrooms added on, the effects it will have on the families living on Ordway, those of us who share an alley, and most importantly, the children that go to school there. Thank you.
I'm Carol Carter, and I live at 1314 Gartland Avenue. And I just want to reiterate that I agree with everything that Patrick and Chris have said. One of my largest concerns is the traffic issue that is already there, and adding additional cars to that, the way on Ordway. What Patrick said is true. It literally backs up all the way to Gallatin Road, and adding more cars to this, I think, is bad for the neighborhood, bad for the environment. But also, I supervised before and after-school childcare for 20 years of my career, and how narrow that street is and how much traffic there is backed up. If I was supervising the exit of those children into those cars, I would be a nervous wreck. And I think adding more students there is not the safest thing. From a neighbor perspective, I appreciate what they have done to make it align more with the historic zoning that is required in our neighborhood. We're very proud to have the school in the neighborhood. I agree that it's wonderful to hear the children playing and laughing, but I just don't think it's the right thing to put more children into a building that's not built to hold that type of capacity.
Great. Are there any questions? We appreciate you coming out and testifying.
Ms. Taylor, as I spoke about before we went to opposition, misplaced your name, I apologize. Ms. Shawnee Dow is here on rebuttal to speak to the traffic situation along Ordway, which was raised by the opposition.
Sure. That's right. Okay. Hi. So I am.
Let me ask our staff, is that if you don't speak ahead, can you come and speak?
Identified by name in advance is probably sufficient under
Okay.
rules.
Okay, great, thank you. Just wanted to make sure we were.
Sure.
Mr. Hargis, I want to hear from your witness, but I just have a few quick questions since we just heard from the opposition.
Certainly.
And these are for you, sir.
Yes, ma'am.
Number one, I thought I understood you to say you have plans to build a new building.
In the next, yes, sorry, go ahead.
Is that correct?
I want to just be really careful about terminology. So we will have a different building that will serve as our middle school, and that building and facility will launch in the next 18 months, no matter what. I think whether that's whether that's a current school that we're moving into and sharing space, whether that's a leased facility or whether that's a new construction, I think it's still a little bit unclear. So I just want to be clear that I'm not saying we're going to build a new building in 18 months, but we will have an additional facility that will serve as our middle school in 18 months.
Is it on that location?
No, ma'am. No, absolutely not. Yeah.
Okay, that was one question I had. Number two, I understood you to say you were going to employ another school bus. And how many children will that school bus transport?
Yeah, anywhere between 50 and 75.
All right. And now I don't remember my other question. If it comes to me, I will ask it. Thank you.
Want to piggyback on one of your questions. In order to fully function as your, elementary school, you need a 4th grade, and that is what you're adding.
Right. So I think it would either, what it would either require, and I want to be thoughtful and respectful of sort of the data points and of families in need and what sort of the reality is of a family that perhaps can't purchase into a geographic priority zone school and what that experience is like in Davidson County. And so our options would either be to take fewer kindergartners every year, so to take 25 or 50 fewer kindergartners. It would be to discontinue the school in 3rd grade and to send our 4th graders, essentially out to neighborhood schools without a real location or spot for them, or to have this modular portable building, which is what schools across the city typically do as they start to overflow their space.
So I'm still not clear on what the traffic fix is. You said you were adding a bus. How many buses do you have now?
Right now we have 3, and so we're adding a 4th school bus.
And so how many students ride those buses now?
So it depends because we did, like I said, pilot aftercare. But we have about like between 130 and 180 children ride the bus each day.
My other question was about the trees. Are you moving the trees that are around the playground?
Sorry, so I think that like we have a landscape architect working with us to try to make sure that we like do not remove any trees that are not necessary to remove, and make sure that we have a plan where like that impact is minimized absolutely. And so I also want to be really careful, and like I hope you appreciate this. I don't want to promise something that ends up being untrue. And so I don't want to say like we will not remove a single tree and then find ourselves in a situation where another person comes to us and says, hey, like you actually do need to remove this. I do want to be really clear that we have like named that as a priority and tried to be really explicit where anywhere that we don't have to, we should not. And we would rather have folks sort of like park around them and so have like a compact only space, things like that, than remove a tree.
Again, I'll piggyback on that one. The planning recommendations mentioned working with the urban forester, I believe. And I believe that you said that you accepted those conditions?
We'll be required to, as a process of the permitting anyway, a signatory to the permit.
Okay, and just as, knowledge out there for the community, the urban forester is concerned with trees as well, and we'll take that very seriously. And he works for Metro.
Sorry, is it Harper? I didn't know, did you have other questions about transportation?
Well, I was just trying to figure out if there was a plan in place to reduce the queue of cars, and does the extra bus mean that right now, I think there's at least 2 buses at a time on the street? There'll be 4 buses on the street at a time?
We would probably stagger them slightly.
And what about the car traffic? Because I know that is a problem. And I've personally driven through that several times myself.
Yeah, I think, I guess I'll share 3 thoughts if that's okay. So one is I stand out at the corner of 12th and Ordway every day, both to monitor safety and to just sort of like keep an eye on the traffic and try to support it. That's because we don't have an assigned crossing guard right now, and crossing guards sort of exist at the nexus of a number of agencies, and we're hopeful to need one. When they've done studies on our requirement for a crossing guard, the folks that have come from the police department and their crossing guard agencies have described our dismissal as actually one of the most efficient they've ever seen. That does not mean that there's not traffic. What it means is that once we start loading cars, we're loading cars about 8 at a time. And in fact, if you look back, when they had to do a news story to get crossing guards, they actually had a news truck just show up at our school and film our dismissal. And again, that was because like there was a belief that what we had could actually be a model for what that process could look like. And this was when we had a crossing guard at our old location, just to be clear. Finally, and I think this is maybe just helpful, we have sort of like a history right now where families will come to school early. So we dismiss at 4 p.m. and maybe a parent gets there at 3:30 and like someone said, they idle. We have not historically discouraged parents from doing that, but we can and say to families, please don't arrive to school prior to 3:50. It's not a message that we've shared before, and we are happy to do it because bottom line, once the line does start to move, and like truly as a point of fact, at 4:06 p.m. traffic was gone yesterday. And so that's about a 5.5 dismissal with more than a 5.5-minute dismissal with more than 100 cars. I think anyone who's ever driven through a school zone is aware that like there is traffic and there are challenges associated with it. And I think there are policies, like concrete ones we could put in place that would help there, in addition to the fact that I think there are programmatic changes we could make, including expanding aftercare and our school bus, that again are costs that we would bear that would like genuinely just reduce the number of cars that have to be on the road at a given time. And I think part of what Mrs. Dowell is here to talk about is actually like what the experience is of a person driving through that as a parent who has children at multiple schools and things like that.
Sure. Hi, I'm Shani Dow. I am a parent, and I also live at 1405 Forest. I actually walk most days, so there is a contingent of parents who do walk, but I drove just this week and was actually surprised when I rolled up at 405 and the dismissal line was totally gone. I do as Mr. Freeman described, a number of parents do get there early. And I think it's because parents are coming from work and making lots of sacrifices to get there. And so I understand as a neighbor, there are inconveniences when you drive through any school zone. But I kind of think of school zones and school traffic as like babies on airplanes. It's the price we pay for a future. And so I know it's not convenient, but I know also that the school has worked as hard as possible to make it as convenient as possible for the neighbors in the neighborhood. Because I live on Forest, which is 2 streets up, I do walk past Gartland and I walk past Ordway. And it is true that Ordway does receive the brunt of kind of the traffic. Having seen, I've walked up 12th and Gartland, I've walked up 14th, and there's not a lot that happens there that I think is due to the traffic. I actually think there's just also a very high traffic area given how much East Nashville is growing. I think the only other perspective I would like to share is just as a parent, I'm really thankful that the school is dedicated to being such a good neighbor. As a parent, though, you also hear all of the additional costs that you kind of sign up for and realize like those are all resources that don't go to kids. And I feel comfortable about my ability to provide kind of additional resources for my child, but I do think about all of the children who are sitting in the school and the resources that do get pulled away from them as we kind of get really, really precise about the ways that we make it a comfortable thing for the neighborhood. And so I just want us to be really thoughtful about both what the school takes on as being a responsible neighbor while also thinking about what the school's purpose is, which is to educate children. Yeah.
Thank you.
Any other questions? In conclusion, I think our application complies with the requirements of 1716-150, that given Historic's approval and our willingness. And I do want to thank Ms. Eno, Ms. Carter, and Mr. Spence for coming today. We had a good neighborhood meeting on Monday, as Charlie talked about, and with the councilman. And I think it's an important school, and we do ask that you approve our request before this board. Thank you.
I do have one last question.
Certainly.
The dumpster is rather close to the alley. Is it possible, and I realize you don't have a civil engineer here, but maybe just to push it back in the site a little bit to create more room for the garbage trucks? Maybe that would alleviate some concerns.
Yeah, I think like one is, in the past, people have had to go through, so people would drive straight and then make a right to get to the parking lot. I don't know if that makes sense. Basically, like, to move it further away from the alley would have made it harder to access parking spaces in the current configuration. In the proposed configuration, that is less true because people will directly go into parking spots. And so I'm not a civil engineer either, but I see no reason why we can't do that. I actually think this proposal will like reduce some of the challenges that the dumpster causes.
Any other questions? Anything else to add? We will close our public hearing and have a discussion. Any thoughts?
Well, having read the application, I'm not really sure they're required to come before us at all. So that being said, I think they meet the requirements. In my opinion, they meet the requirements for a special exception. I think we had some very well articulated opposition. I am hopeful that those concerns will be addressed. It sounds like the number of students is going to be capped with this grade, and they won't have additional students coming after that. But, I don't want to cut them off at 3rd grade. I mean, they need the 4th grade to be there on the property. It sounds like they've tried to be a good neighbor. It sounds like the opposition have been good neighbors. So I would move, well, we can discuss, and then I'm happy to go further.
Yeah, I agree. I think that certainly from the testimony today, every concern has been met with a receptiveness and a seriousness that, and a sincere attempt to address as best one can, given the geographic constraints that you have. I do think that agreeing to the Planning Commission's Planning Department staff's recommendations are important. I do think that any motion could include a recommendation and a hope that they would respect the mature trees, which I think they testified that they would, and really don't doubt that they would. and give special consideration to the dumpster, which, again, they've, I think, testified before it was raised. But it feels like that they, and based on the testimony, while I certainly understand the neighbors' concerns, and I think there may still be issues, but by nature of having a school next to you, the response and the, to those concerns, I think, is sincere and been substantive. I think the changes from the original proposal to what currently is supported by the Planning Commission staff and the council member
And
historic. Metro Historic Zoning Commission reflects that journey. And I think that's something to applaud the applicant for.
I guess I would ask, if we're dealing with a charter school, they're not under the same gun that a regular neighborhood school is. Neighborhood schools have to accommodate whoever lives there. And I live in a community with many, many, many modulars behind all the schools. Grade school, we're growing so fast. Every school in Southeast Nashville is 100 to 120% over capacity. But this school does have some choice as to how many students they take. A charter school is different. And I was very concerned about what Mr. Spence said about that building having been rejected, in essence, by M&PS. So I guess I'd like to go on record as saying that I want to note that because I thought it was an important comment.
My concerns, we have asked a lot of questions and a lot of issues have been addressed, but I don't feel like the issues have been completely answered. A lot of the answers have been, that's within the realm of possibility. That's something we could do. And there's obviously a lot of issues, and I'm not interested in putting conditions on a whole bunch of issues, but my reservations are, about the traffic. It's not bad when it's working, because when it's working, it's working. It's the half hour to sometimes longer before pickup that I've seen traffic backed up, idling or not. It's a lot of additional traffic. So I would be interested in exploring with the committee, perhaps putting a time limit on it and thus bringing them back for review in, say, 2 or 3 years to see if these things that could be addressed do get addressed, and if the neighbors are being satisfied. Otherwise, we're giving them a 7-year blank check in a way to, fix the problem, don't fix the problem, use the bus, don't use the bus, whatever. But, let's see if these possibilities are workable. Give them the benefit of the doubt for, 2 or 3 years.
I concur with everything that Cynthia had to say, specifically about, I don't know if we even needed to be before this body, but I thought you were going to make a motion, I was going to second it, so I'm with you.
Well, and that was, and that's where I fall too. I mean, and another, again, to me, I credit the applicant for one, believing with some supporting documentation from Metro Legal and one of our attorneys reading this information that they may not even need to come here, and the fact that they are coming here to say, hey, we're going to go through this process because, one, it'll be a better outcome for the neighborhood. It solidifies the legitimacy of the decision because but it also says, no, we're going to go through this process and we're going to work it out. To me, I think that's an admirable step, and the evidence seems to be that they have responded to that. So, is it, does everybody, would it be nicer if it were a multi-acre campus and at a different spot? I don't know. I mean, maybe to some extent, but we've also heard and have probably 40 or 50 letters from parents and others that neighbors that say, no, this is a really great place and they do a really good job and it's a good school. So, I do have a little bit of hesitancy on putting a condition for such a large capital expenditure. I think it keeps one honest to have to come back, but to maybe have a different board and a different, a different opinion of the community and whatnot. I mean, I'm just saying a general state of, it would make it tough for me to invest any capital as a business person or if I knew I had a 3-year window. It's just too short. So, I mean, I don't mind. I like what you're trying to get to, but I don't know about the.
So I guess I'm wondering, and maybe 3 years isn't the right number, but I just wonder how we keep them, how we hold them accountable to things they say that they're fine with doing, without stipulating individually in the motion and are fine. And to piggyback that, if we don't think we need to hear this, then we shouldn't take action on it. I think that if we, they say we don't have jurisdiction, but they're here for a reason, and it's either to have this on the record or whatever. But if, as a board, if there's some question whether or not we have jurisdiction, then we shouldn't hear it, or somebody should tell us we don't have jurisdiction. I wonder if legal has any thought on that.
So I think that historically Metro Legal's position has been that charter schools are not exempt from our zoning code. There is certainly argument on both sides, and our basis for that position has been that there are multiple factors courts look at in determining that schools are exempt from local zoning provisions. The Board of Education has the level of control over the charter school might vary from school to school. For example, there are a series of different issues that the courts have looked at, and so based on those criteria, our position has been that charter schools are different from just your straight up public school, MNPS schools. But again, I think there's an argument that can be made both ways. That has been Metro Legal's position historically, is that additionally, I believe in the past, MNPS has tried to comply with our zoning. I mean, MNPS flat out is exempt from our zoning code, but they have still tried to comply, and I believe successfully tried to comply with our zoning code. But there's an ordinance, Metro Code 2.06.010, says that it should be the policy of Metro government not to exempt itself from its own code. So, and again, that's a policy, but it's also an ordinance that says it should be the policy. I'm guessing that's why MNPS has always tried to comply with our zoning code. So I think Mr. Hargis makes an argument, a fair argument, and I think that there could be discussion regarding that. But Metro Legal's position has been that charter schools are different from public schools and they need to comply with the zoning code. But that being said, if you think they meet the criteria for granting a special exception, I think you can grant the special exception. But to answer your question about whether or not it's properly before the board, that's why I think it's properly before the board.
But I wanted to just address the time limit, which I think, I had not thought about that. I would have they can only have this building for 7 years anyway. And as I look at it, the special exception, we had to do it because where it's going to be placed, not on the use of the property. Mm-hmm. And so I'm not real sold on giving a time limit on it. But I could talk further if you think that's, if your position is that's the only way you're comfortable with it.
Well, it's not the only way, but I do think that they're increasing the capacity quite a bit. And when we talk about special exemptions, we do talk about the the impact on the neighboring environment. That's why neighbors come in, and that's why the applicant says we want to do right, and I believe them. Right. 7 years. I mean, there's students that haven't been born yet that'll be in that 7 years, so it's a lifetime. And for the neighbors, it's a really long time.
But there's a history, though, of that property of, I mean, it's going on an existing concrete pad that used to house modular classrooms, I believe that was the testimony. So, I mean, there's a history of this piece of property for different educational institutions to have,
Well, that's true, and, you know, and I wasn't here in 1980, and, you know, I don't know what the traffic situation was. I don't know if it was all bused, if it was all, you know, walked or what. I know there is a traffic concern now, and we're increasing the capacity, and I hope that it will work, and I'm sure it's going to pass, but I just wonder if there's any way we can encourage, you know, to work out. But I might be the only one, so.
Well, and again, beyond, you know, is there something between just making it public that you hear what the criteria are? If you don't meet the criteria, then show cause, come back, complain, say. It sounds to me that, you know, and again, I don't know the applicant. I didn't know of the school until today, or well, other than the application. But it seems, you know, based on the testimony and the journey, and that there is a responsiveness that gives me more confidence than I've had with other, not school applicants, but other applicants where you just really aren't so sure they're going to do what they say. Certainly the testimony and the presentation lends one to believe that they'll do it. If there are measures or incentives or deadlines or that type of thing that are necessary for it, then I'd be willing to talk about it. But I share the importance, but I'm not, again, I'm not, don't go there, so it's not my neighborhood, so it.
So, I mean, one thing that I forgot to ask is if there was any additional plans to expand this. And I'm assuming they had to come before a board to get maybe they didn't, because since it was already a school.
I remember that answer. They didn't have anything additionally. They're stopping at 4th grade.
Yeah, the testimony was at middle school, but not at this location.
Right, but that doesn't really, I'm assuming that they're not going to want to add more modulars later. But I think if we were to put that condition in, that I would be willing to go along with it. Again, I might be the only one with this concern, so out of 6 of us, so you might not, you know, don't let the tail wag the dog here.
I mean, I would make a motion that they meet the criteria for a special exception, and that we grant, subject to their compliance with the recommendations by, who made them? Planning? By the Planning Commission.
I would second with, if you wouldn't mind, an amendment that says that the alley limits that the Planning Department staff recommended be that the alley parking is limited to staff, and that the applicant give special consideration to the mature trees in their planning and special consideration to dumpster placement to minimize impact of the neighbors, and that the alley itself be limited to necessary deliveries only, predominantly kitchen, which is what they testified they needed. If that.
I'm agreeable to those amendments. Second?
Yes, second.
Okay.
So there's a motion and a second. Is there discussion or any additional amendments or thoughts? Okay, all in favor of the amendment or the motion as presented and amended, say aye. Aye. Opposed, say no, or raise your hand. How many did you vote?
Yes, I said yes.
Yes, okay, so it passes 5-1.
I'm sorry, I didn't see you.
Mr. Chairman, that concludes our business for today.
Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.